Whitey's here, but then he still doesn't find what he's looking for here anyway.
On behalf of the Center for Constitutional Studies at Utah Valley University, I extend a very heartfelt welcome to you all for our annual Constitution Week conference. Scott Paul, I serve here as the director of the Center for Constitutional Studies. The colleagues and I are thrilled to be back on campus in the same room as at least some of our audience. It's been almost 2 years since our last in-person conference, so we're ecstatic to be able to share the magic of the classroom with students and guests once more. We recognize that today is Yom Kippur. To all our friends who've been observing high holy days, Gemar Chaftima Tova. Speaking on behalf of my colleagues, we look forward to spending these 2 days with you, considering pressing issues and how these issues may be affected by considerations of the structure and makeup of the U.S. Supreme Court. On April 9th, 2021, President Biden issued Executive Order 14023, forming the Presidential Commission on the Supreme Court of the United States, comprised of a bipartisan group of experts on the court and the court reform debate. The commission's purpose is to provide an analysis of the principal arguments and the contemporary public debate for and against Supreme Court reform, including an appraisal of the merits and legality of particular reform proposals. The topics it will examine include the genesis of the reform debate, the court's role in the constitutional system, the membership, the size of the court, and the court's case selection rules and practices. If those topics sound serious and significant, they are. The Biden Commission is considering everything from maintaining the status quo to fundamentally altering one of the 3 branches of government. As we'll hear during this conference, the structure and role of the Supreme Court is being a point of debate throughout our nation's history. During the next 2 days, we'll consider the history and structure of the court, with particular attention to moments of court reform, whether contemplated, attempted, or implemented. I express appreciation for the excellent speakers who will join us for this conference, either in person or online. Again, it's wonderful to have our guests with us on campus. I also need to acknowledge at the outset of the conference the many Center for Constitutional Studies staff who have organized this conference. Carrie Dennis, our events and marketing manager, deserves special recognition, as do the nearly 20 Eric Zachary Wood, student research assistant who work in our center. One final note, each session today will include time for questions from the audience. So whether you are here in person or watching online, we encourage you to submit questions either in the chat function of our YouTube channel or by emailing constitution@uvu.edu. Again, please submit questions for our speakers in chat on YouTube or by emailing constitution@uvu.edu. Now, I'm pleased to introduce to you Hector Manzanares. Hector is a senior here at UVU majoring in political science. He is also an Eric Zachary Wood student research assistant in the Center for Constitutional Studies, where he works on the Quill Project, a groundbreaking research partnership with the University of Oxford. Hector will introduce our speaker for this session. Hector?
Everyone, very honored to introduce our first speaker for this session. Dr. Matthew Broadman is an associate professor of political science at the University of Texas at San Antonio, where he teaches a wide array of courses related to constitutional law, politics, political philosophy, and political research. He holds a PhD in political science from Baylor University. His research examines the creation and development of the federal judiciary, as well as American political thought and constitutional development more broadly. Dr. Matthew Broadman.
Thank you, Hector. Good morning. And I want to add my own thanks to the Center for Constitutional Studies and to UVU for the invitation to address you on these questions of the moment for us regarding the Supreme Court and its role in our polity. I've been encouraged by seeing all of the work that students are doing in the Center for Constitutional Studies and the Quill Project, which is something I wish had existed whenever I was writing the dissertation that included trying to map out what was going on at the Constitutional Convention. It's a very handy tool. Something I got to spend a little time tinkering around with last night and found intriguing and helpful. I'm going to talk to you this morning about the creation of Article 3 in the Federal Convention of 1787. This is its formal title, what we commonly call the Constitutional Convention, but of course, as all of these students mapping constitutional deliberative processes for the Quill Project know, the Constitutional Convention doesn't tell you much because we do constitutional conventions a lot, or we used to. Maybe we don't do them so much anymore. But we're going to deal with the Federal Convention of 1787, which is the deliberative body that produced the text of the original Constitution, which was then submitted to the states for ratification in 1787, ratified in 1789, went into operation, or ratified in 1788, went into operation in 1789, and remains the basic structure of our polity. Before I dive into what's going on in the convention and creating the judiciary, though, I want to set up a bit of a problem. Something that I think describes at least a large part, by no means the whole, but describes a large part of what is controversial and difficult about the Supreme Court in our polity. We commonly speak of the Supreme Court settling constitutional questions or settling other legal questions of moment. And indeed, when the Supreme Court decides which cases it will take, because of course one of the distinguishing features of our Supreme Court is that it does, or has for just over 100 years now, made its own decisions about which cases it will and will not decide. It decides what to decide. And when it does that, the court itself employs a metric by which it tries to measure, is this case of sufficient importance to the public that we should include it among the relatively few cases that we actually hear? Is it among the lucky 1%, or these days a little less than that, of the cases that people ask us to hear that we will in fact hear? And in answering that question, the judges necessarily engage in a thought process that considers, when they ask the question, is this case before us of importance to the public? Or is it only important to the parties in the case? That seems like a fairly non-controversial question to ask, but it raises a serious problem for the judicial process. Because courts are designed, the virtue of courts, the structure of courts, the judicial process itself is a process that is designed to address concrete issues in a real controversy between two or more parties in a particular set of circumstances. In general terms, we could say judicial processes are usually retrospective and their decisions of limited applicability. That is, they're considering what has already occurred or what is occurring and wish to apply existing law, that is general prospective laws that apply to all similarly situated persons and circumstances, to a concrete set of events or circumstances that have already occurred. This contrasts quite vividly with the legislative process. And a legislative process in a Republican government is designed to be quite the opposite, prospective in general. In fact, what we see as a virtue in a judicial process, that is a careful consideration of the case at hand, of the facts that have arisen in a particular case, and the crafting of a reading of the law to address that set of facts, is something that we might question in a legislature. What's a virtue in the judicial process might be a vice in a legislative process. If I told you the legislature was considering a piece of legislation that dealt with just two parties, two individuals, and a dispute that had arisen between them, and that the legislature was going to decide this dispute between these individuals and issue a law that would apply only to those parties, I hope you would be alarmed, because you would think the virtue of legislatures is that they make general laws that will apply even-handedly to all similarly situated persons, and under which the legislators themselves will live. That's the guarantee of a Republican legislative process. So legislative and judicial processes are designed quite differently. I'm describing these in really stark terms and in very general terms, and in practice, we encounter quite a bit of gray area. But at least part of the controversy over the way that the Supreme Court works, whenever we speak of the court settling questions, is that we think of the court as engaged in an activity of settling prospectively for the future large questions of the public interest in ways that will apply to the public at large. Not simply to settle a controversy between discrete parties in a concrete set of circumstances, but to settle the question for the public going forward in the future. And thus that kind of judicial activity winds up sounding very much like my description of legislative activity. And this inspires the charges of legislating for the bench and the court sitting as a super legislature and so forth. A shorthand way of putting this is that the American judicial system, or the American constitutional system as a whole, marries a case-bound judicial process to a very broad constitutional task. It's a judicial process that's designed to do a very specific thing and do it well, and asks it to do something much bigger and much broader. In fact, if we look abroad and we look at other constitutional systems, other polities have chosen to do this differently, and quite often scholars of comparative politics, scholars who look at courts abroad in comparison to their own, would argue, often do argue, that other polities do this better. The Europeans have navigated this better than we do. Instead of asking an ordinary court with an ordinary judicial process to try to handle these big questions of constitutional meaning, which are fundamentally political questions, they would say, instead of doing that with ordinary courts, European polities have more commonly employed constitutional councils or separate constitutional tribunals that are separate and cordoned off from the ordinary judicial process, so that the political controversy that surrounds the settlement of big constitutional questions doesn't taint the legitimacy of the judiciary, which remains above those large political questions. But so goes the criticism. And you could find the same criticism in any number of places. For you, the literature. But the argument I want to make, or what I want to draw out of the Constitutional Convention today, and our consideration of it, is that the framers considered alternative ways to settle constitutional disputes. They considered alternatives to judicial settlement of constitutional questions, which they knew would be of great public moment and spark great controversy. But at the end of the day in the convention, it was judicial review that was left standing as the institutional tool that would actually be charged with handling this task. In other words, as a student put it to me yesterday after having a conversation about this, the problem is baked into the cake from the founding. It's a basic ingredient of the constitutional order. So what I want to try to do is condense an account of the convention's deliberations on the Supreme Court in a way that allows us to see some of the alternatives, radically different alternatives that existed for the framers to try to settle constitutional conflict, and especially federal conflict. So the kind of conflict that the framers most clearly anticipate when they set about the task of framing the Constitution is federal conflict. That is conflict over either the scope of federal power or state encroachment on federal prerogatives. The reason this is foremost in their minds is because of their experience of the Articles of Confederation. You're all familiar with this from your American government classes that you've had at some point. The Articles put the federal government in the position of relying on states as intermediaries to achieve their various aims. The federal government had very few institutional tools with which to enforce their own policies. They had no real executive or judicial institutions, no, as Madison would put it in the convention later, no arms and legs to act and move. Congress was just a body. And thus it was reliant on the states to implement its policies. This reliance put the states in a very advantageous position in some ways because it meant that when conflicts arose over the proper scope of federal power, it was sufficient for the states to simply maintain inaction to frustrate federal policy. If the federal government is dependent on states to implement its policies, the state really need not interfere at all with the implementation of federal policy. All it needs to do is withhold its assistance. Inaction is sufficient to frustrate the pursuit of federal aims. So the basic solution to that, as many of you already know, I'm sure, was direct enforcement. We'll create a constitutional order with its own executive and judicial institutions, can carry out its laws directly on individuals. No longer will states stand as the intermediary between the federal government and the people, with the states in between mediating that relationship. Instead, now, the federal government and the respective states would concurrently govern the same set of citizens through their own institutions and under their own constitutions. And this would, in the words of one of the framers, obviate as much as possible all interference between the federal and state governments. But that as much as possible is really important, because it's not really possible to eliminate all interference between the federal and state governments. Even two governments that concurrently govern the same citizens, states are no longer in the position to frustrate federal policy by inaction, at least not until the rise of modern cooperative federalism, that is. But they're not really in the position of being able to frustrate federal policy through inaction anymore. But with two governments concurrently governing the same set of citizens, they may lay conflicting obligations on those citizens. Or they may object to the obligations that one level imposes on citizens, and the other level of government finds to be despotic. So this leaves us with the question of mediating these kinds of conflicts that would arise. So we get a number, and this issue of managing federal conflict is very much at the forefront of the debate. You see it in every successive plan that's presented at the convention. Many people are familiar with the notion that the Virginia delegates show up with a Virginia plan, which is often credited to Madison's efforts. And small states produced the New Jersey plan in response. Hamilton had his own long-winded speech laying out his own ideas about how we ought to manage this. And then most of you know the convention opted to pursue the Virginia plan, to adopt it as at least a basis for its deliberations, which it did for better than a month before it went into a committee, and then a committee of detail came up with its own elaboration and expansion on these previous proposals and so forth. But in the midst of all of these successive plans, every one of the major efforts to put forward a new system address this problem. So I want to consider these in turn. Probably the most important alternative, probably the most popular alternative among modern scholars when they look at the convention, to what we ultimately wound up with, are Madison's own proposals, which find little success. James Madison, despite his title as father of the Constitution, suffered some very serious blows in the Constitution. And two of the biggest were two proposals that he put forward to deal with constitutional conflict. Madison did not think that courts would be adequate to deal with constitutional conflict, and so he proposed two others that show up in the initial Virginia plan. One is a veto on state laws to be exercised by Congress. Congress, under Madison's plan, was to have the power to veto any piece of state legislation, which, in the opinion of Congress, contravened the Constitution. So if Congress thought it was unconstitutional, they could veto any piece of state legislation. This actually survives for a while. The veto on state laws actually escapes it when it's first considered. It actually faces no serious controversy. There's no, even though they take a vote on a motion, it just sort of skates on through early on without a lot of criticism. It will later fall, but it was coupled with another institution that was of immense importance, and that was a Council of Revision. So whereas the veto on state laws would ensure that states could not encroach on federal interests or encroach on constitutional limits, the Council of Revision would be a body composed of the president and a number of federal judges. And this Council of Revision would review all federal legislation before it took effect. So much as laws are presented to the president for his veto or signature, the Council of Revision would stand in that place, but its name suggested something more. It suggested deliberation on the laws that Congress produced. And indeed, there's talk when Madison comes to defend this institution, he describes it as adding the wisdom and perspicacity of the judges to the law. You get the judges involved in the Council of Revision, as its name suggests, they could not just sort of turn down or approve legislation, but actually suggest improvements to the law. Become something of it would become something of a consultation. Of course, the president, because of his veto power, enjoys a lot of initiative in the legislative process. We would have to assume that if this body of judges was involved in the exercise of a veto, it wouldn't just be the president taking initiative in the legislative process. Whichever judges sat on this council would surely be consulted in the formation of legislation. That this is what Madison has in mind is clear from his comments. But the Council of Revision goes down hard and early. It doesn't survive even the first debate on the provision. And the reasons why are important. The delegates, a wide variety of delegates, object to it on two grounds really. First, that it will politicize judges. If judges get involved in the formation of legislation, they'll be embroiled in legislative politics. And that will undermine the independence of the judiciary. we now say legitimacy, but the idea of judicial legitimacy isn't really a terminology that's current at the time. But I think that the sense is more or less the same. Moreover, the argument was it's unnecessary because, as a number of delegates note, from a surprising variety of backgrounds, we sometimes think of the convention as sort of like small state, big state, nationalist, decentralist, and so forth. But delegates from a surprising array of backgrounds raised the objection that, well, the council revision is really not necessary. There's no necessity to involve the judges. Why? Because judges will get involved in their judicial capacity already. And the judges will have a chance to invalidate unconstitutional legislation when it comes before them in concrete cases. Madison objects to this, and his objections are quite interesting. His response is that, well, first, if judges confront these pieces of legislation on the bench, they'll only be able to consider their constitutional, their constitutionality, their legal credentials. But he wants judges involved in the wisdom of legislation. Says if laws come before judges on the bench, they'll be confined merely to jurisprudential considerations, legal modes of reasoning. And I want judges involved in establishing and improving the wisdom of laws. And that wouldn't be accomplished. Moreover, he thinks judicial review is too weak. This would only occur after the law has been enforced. Judges can only address the constitutionality of legislation under the theory of judicial review that the framers are operating under once it's been enforced and an injury has been incurred by some person and it arises in a concrete case. Madison says it's too late. The law's enforced. I want the judges involved earlier when they can improve the legislation or stop it before it ever goes into effect. Of course, we found a way to simulate this with the preliminary injunction. In effect, the modern creation of the preliminary injunction to stop enforcement of a law pending all judicial proceedings on the law is basically to put the judges in to a pre-enforcement role to ensure that the law does no damage before the judges can get to it. Madison's anticipating this need. Saying we're not going to be satisfied with getting judges involved after the injuries occurred. We're going to want judges involved earlier on the abstract question of is this legislation constitutional or not? But Madison loses, and he loses big, because of the framers' attachment to the conception of judges as non-political and as in a process that deals with concrete cases. Live controversies between injured parties. So we get rid of the council revision, and whenever we get to the next stage of the convention, we have the Virginia plan modified now with an executive veto to be exercised by the president alone. It's familiar to us. And here with federal jurisdiction that extends to all laws made by the Union, so any case arising under a law made by the United States, and to any questions which involve the national peace and harmony. So you can see the dual concerns there. Even the way in the first couple of weeks of the convention, the way federal jurisdiction is described in the federal courts is these dual concerns. We need courts to have jurisdiction that is coextensive with the national laws so we can effectively, directly enforce those laws. That first method we talked about of going around the states and directly to the people and thus avoiding federal conflict and having direct federal enforcement. That's what the whole laws is about. But on the other side, also, any cases that involve, or actually they use the term question, any question that involves the national peace and harmony. This concern with broiling conflicts that may arise. Well, you all know that the Virginia plan meets immediate opposition. It envisions a very powerful government with these powers of direct enforcement. The small states are skeptical. And the alternative is proposed, the New Jersey plan. And the New Jersey plan has a different way of dealing with federal conflict. The New Jersey plan does a few things. One, it shrinks federal jurisdiction or the federal court system to get rid of inferior courts. There's just be a Supreme Court. And it shrinks jurisdiction so that the Supreme Court's jurisdiction will not even extend as far as all the laws. So there'll be no concurrence between the extent of federal legislation and the extent of federal jurisdiction. So who's going to decide these cases? That have to be state judges. This is the decentralist alternative that will rely on state judges. We've already got courts sprinkled all over the country. They're quite competent. Just use them. So here we have a reliance on state courts that emerges in the New Jersey plan. And that tends to undermine the direct enforcement leg of Madison's approach, or what I could call generally the nationalist approach. They want to equip the federal government as much as possible with institutions to directly enforce federal law. And that's the principal solution. The New Jersey plan reveals the decentralist alternative, which is, well, let's scale back those institutions. We'll give you an executive, but not courts. We'll let you have a Supreme Court, but not a Supreme Court that can deal with everything that comes up under federal law. Only a handful of things, special categories of things, where we may need national uniformity. Everything else is to be handled by state judges, a state officer. This would continue the kind of reliance on state institutions that the Articles of Confederation had employed on a widespread basis. But the New Jersey plan does something else very interesting. If you're going to rely on state judges, what's to say that the state judges are going to look out for federal interests? So they put in a supremacy clause. This might surprise you. The supremacy clause in the Constitution, which declares federal law to be supreme over state law, and declares that judges in every state have to give preference to federal law over state law when they conflict, actually originated in the New Jersey plan. It was a decentralist proposal, but it was coupled with this reliance on state judges. It was a trade, right? The New Jersey plan traded. They said, you let us use state judges, and we'll put a provision in the Constitution that says those judges have to resolve any conflicts between federal and state law in favor of the federal law. So we get this provision that all laws made by the United States are going to be the supreme law of the respective states. And that the judges in every state are going to be bound thereby, anything in the laws of any state to the contrary notwithstanding. Now that language I just used is not identical to the supremacy clause that is in this Constitution now. It's going to change in important ways, but we'll come to that. But it's introduced here. It actually went further. It didn't just rely on state judges. There was an understanding that, well, states may refuse to obey their judges. Political branches are not always great about conforming to judicial directives, judicial decisions. What to do if a state is recalcitrant, resists. So the New Jersey plan then authorized, in the last instance, the federal executive to call out the force of the union, to coerce wayward states into conformity with federal law if they resist it. This runs into some real controversy because, as a number of delegates point out, the whole purpose of direct enforcement, of providing the federal government with more institutions so that they could enforce their own laws, was to avoid confrontations, especially armed confrontations, between the federal government and the states. Because there is a word for coercing a political body through the use of force to do a thing. It's war. In this case, civil war. The New Jersey plan envisions the backup plan, Plan B, is civil war. It's a bad idea. The whole point of designing this constitutional system and coming up with institutional mechanisms for settling federal conflict was to avoid armed confrontation. Of course, you all know, you're not that naive. Armed confrontation is always a possibility, but you don't write it into your Constitution. It's like a right of revolution. Sure, it's always there, but you don't put it in the law. It's necessarily an extra legal thing. To resort to force is to go outside the law. To resort to war is to step beyond the Constitution, at least inside of a political war. You can include war powers in the Constitution. Okay, now here comes Hamilton. Hamilton's frustrated. Says, you guys have some, okay, direct enforcement, fine, okay. I'm glad you all see the need to provide some sort of auxiliary control on state encroachment on federal power. But the things you all are proposing aren't really adequate. You're all talking about judges, which Hamilton likes. I mean, this is the Hamilton who writes Federalist 78. It's not like he has an issue. He's also the Hamilton that had argued in colonial courts for the exercise of judicial review well before the Revolution. All right, I put that wrong. In New York courts in the midst of the Revolution. But Hamilton thinks, like Madison, he shares something here. All this is inadequate. You're not paying enough attention to the political forces, right? We're dealing with politics. It's not just an academic debate. So he thinks you need something more muscular, something more real institutionally, something grounded in politics. So what's Hamilton's idea? Hamilton has a really innovative idea. It's one nobody's tried. And the convention doesn't really seriously consider it, but here's Hamilton's idea. We'll give the governor of every state. So in the federal constitution, we will confer on all the governors in the United States an absolute veto over state legislation. And we'll have Congress appoint the governors. So we'll make the governor of every state a federal officer and give him an absolute veto over state law. This solves everything. Actually, this solves all the problems. You know, one of the complaints about Madison's veto on state laws was, okay, fine, but here's the thing. Does Congress really have time to review every piece of state legislation that comes up, review it and render a decision on it before it goes into effect? Won't this just slow down the ability of states to do things they need to do? Hamilton's plan solves this problem. Don't have to send anything to Congress. You got a federal officer right there in every state with an absolute veto. So Hamilton wants to co-opt the state governors, state executives, make them into federal officers. That goes nowhere. This really does go nowhere. So, of course, as you all know, about this time, we're 3 weeks into the real deliberations of the convention at this point. The convention says, you know, we'll just stick with the Virginia plan for now. We'll just start there, move on. So the Virginia plan becomes the basis. And as it stands at that point, we have a constitutional veto on state laws, which is going to fall within a month, the next time it gets considered. Delegates are going to reject it. We have an executive with the power of direct enforcement. And we have federal jurisdiction over questions involving the national peace and harmony and any cases arising out of national law. Sounds pretty good. But of course, the supremacy clause had died with the New Jersey plan. New Jersey plan's gone away. Supremacy clause disappeared. So how did it get in the Constitution after all? Well, a month later, the veto on state laws comes. And it fails for some of the reasons I've already mentioned. They reject the Madison's veto on state laws. And Luther Martin, who's going to be an important anti-federalist, says, I have a consolation for you. Let's put a supremacy clause in. Not an original idea, right? He says, we'll put so he re-proposes the supremacy clause in the New Jersey plan. And it goes in without any real controversy. But he had also hedged it about with all kinds of qualifications. Importantly, you'll notice, and I'll quote it to you again, or at least some version of it, the supremacy clause that the New Jersey plan included, and that Luther Martin sticks in later in the convention, says that all laws made by the United States shall be the supreme law in every state. And the judges in every state are going to be bound thereby, anything in the laws of the states notwithstanding. Now you notice there's an important word missing. Some of you already caught it. It didn't say anything about constitutions. The supremacy clause we have now says this Constitution, all laws made in pursuance thereof, and treaties made under the authority of the United States are the supreme law of the land. The judges in every state should be bound thereby, anything in the laws or constitutions of any state to the contrary notwithstanding. What's the importance of Constitution wiggling its way through? On August 23rd, John Rutledge, working from this supremacy clause that originated with the New Jersey plan and then Martin sticks back in Constitution. This Constitution and all laws made in pursuance thereof shall be the supreme law of the land. And now state judges will be bound not only by laws that Congress makes, but by the Constitution itself. This is coupled with a similar change elsewhere. Federal jurisdiction had continued to extend to any cases arising under laws of the United States and treaties. But late in August, Dr. Johnson, not the one who wrote the dictionary, Dr. Johnson proposes to put this Constitution in the jurisdictional menu too. So that now federal jurisdiction reads, the judicial power shall extend to all cases arising under this Constitution, laws of the United States, and treaties made under their authority. Why are those changes important? Well, let's think about this for a moment. If only laws made by Congress are the supreme law of the land, then unless Congress legislates on a matter, there's no basis for finding a state law contrary to it. And if federal jurisdiction, if the power of federal courts only reaches as far as legislation passed by Congress, what if Congress chooses not to legislate on an issue? As long as federal jurisdiction and the supremacy clause only reach as far as laws made by Congress, a statute law, then legislative action is going to define the scope of federal conflict. What's the importance of this? Let's consider the 14th Amendment for a moment. The 14th Amendment, nowhere in it mentions anything about judicial action or federal jurisdiction. The 14th Amendment, as a Reconstruction Amendment, confers birthright citizenship and confers a body of constitutional rights on individuals and protects them from state violation. It never explicitly confers any power on federal courts to do anything with respect to these rights. It does in Section 5 confer a very clear power on Congress, that Congress shall have power to enforce the provisions of this amendment by appropriate legislation. But there's not word one conferring additional jurisdiction on the courts. Now let's say that the supremacy clause only says laws of the United States and treaties made are the supreme law of the land, and that the jurisdictional menu in Article 3 says the judicial power extends to laws of the United States and treaties. And there's no mention of the Constitution as a justiciable source of law. And we have the 14th Amendment as it's now written. And Congress chooses not to pass civil rights legislation. As the 14th Amendment clearly says, states shall make no law abridging. No state shall make any law, make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor deprive any person of life, liberty, or property of the due process of law, nor deny to any person its jurisdiction the protection of the rights. So it confers those rights. Congress clearly has power to enforce that, but what if they choose not to? Or only choose to write legislation enforcing a portion of it? Federal courts would clearly have jurisdiction under those laws, those civil rights laws. But could the court reach further and protect civil liberties or civil rights that might be contained in the 14th Amendment or even other provisions of the Constitution, but that had never been enforced through federal legislation? In other words, if it's only federal laws that furnish a ground for federal jurisdiction, and it's only federal laws that constitute the supreme law of the land, then Congress decides the scope of constitutional rights. Because only a piece of legislation Congress has passed protecting a right would actually be actionable in a court. That's why this is so important. Making the Constitution a justiciable source of law, saying that this Constitution and all laws made pursuant thereof the supreme law of the land, and saying the judicial power shall extend to all cases arising under this Constitution, laws of the United States and treaties made under their authority. By adding the Constitution as a justiciable source of law, it means that legislative inaction will not nullify constitutional limits on states. Constitutional limits on states, things like the Article 1, Section 10 Contracts Clause, become judicially enforceable against states, even if Congress never legislates about them and has no interest in them. It gives federal courts initiative in deciding the scope of constitutional limits on states, both under the original Constitution and under the Reconstruction Amendments. It's the reason that there is no Section 6 saying that the judicial power shall extend to all cases arising under this provision, because that was already covered. Anything in the Constitution is already justiciable law, judicially actionable, at least in theory. Judicial protection doesn't need to wait on legislative action. So this inclusion is enormously important, and Madison sees it. The framers are aware of it. As soon as Johnson suggests this inclusion, Madison actually raises an objection. He says, wait a minute, I'm not so sure I want to make the judges the final arbiters of constitutional meaning. And actually, then there's a little debate that goes on. People said, no, that's not what we're doing. What we're saying is that when a case comes up in court, the judges can use the Constitution to settle the case. We're not saying then the judges decide all constitutional questions. They only decide them in cases. And Madison actually writes in the notes, in his recording in the notes, he says that this is limited. When it passed, it said it being assumed that it was limited to cases of a judiciary nature. In other words, settling cases arising under the Constitution didn't mean that the courts could just hypothetically consider any constitutional dispute. The court couldn't just reach out and decide the question of gay marriage. The court would have to wait for that to arise in a concrete case. What does all this mean? At all these points, when the framers faced alternative means, political institutions that could settle constitutional controversy and federal conflict, they continually push that conflict into judicial forums, making it a matter of law. That has real drawbacks that you see in the objections of Madison and others. There's a real question about whether the judicial process is adequate to handle that task. Or is there a mismatch between the institutional process of judicial decision-making and the momentous task that's been assigned to it? A misfit between the tools of the judicial process and the task of constitutional adjudication. I've actually argued that that tension is healthy. That the framers put it in the judicial process because they want to limit courts, and that they leave courts as courts of law limited to concrete circumstances, because that'll encourage a measure of judicial modesty. It makes the institution more modest. There's an internal tension, but the tension's good. But there are some real questions here. Would we have been better off with Madison's political alternatives? Do the Europeans really do it better by creating special constitutional courts and insulating ordinary judges from politicization? And of course, then, if we're going to talk about the convention, we could always ask the question, why look at this secret drafting history for guidance on the Constitution anyway? Nobody really knew anything about it for 50 years. So those are at least some of the questions that we could address. But I'll leave it there. And I appreciate your time and attention, and I'll turn it over to Scott for questions.
So,
Should I stay here?
yeah, why don't you stay
Okay.
right here? So we thank you for Mr. Barton. We've got some questions. We've got time maybe to take one quick one before we head down to our next session. We've got a few good ones. I'm going to just go with the first one in. So does judicial review illustrate the practical need for an absolute negative power that was originally rejected by the founders?
Oh, that's a good question. Yeah, I mean, I think Madison would say no, because you need the interpretive contest. You actually don't need a final, and even judicial review is not an absolute negative. It really isn't. I mean, we can overturn judicial decisions through constitutional amendment. Presidents and the head of new party coalitions routinely challenge judicial supremacy in what is a fairly healthy cycle in American politics. So even and maybe that goes to my point that judicial review is modest enough. It's not really a nuclear weapon. It's not the nuclear option, and that's good, because in a way it means the debate continues and there are constant opportunities for revisiting the question. Do we have time for one more?
We think we'll have time this afternoon
Okay.
to take, because some of them are very forward-looking, and I think
Okay.
in our final session of the day, we'll have a chance to put those to you. Well, here, actually, why don't we applaud our. It occurs to me, I have not heard applause at the end of a talk in quite a while. That's kind of nice. So thank you again, Dr. Brogdon, for your excellent presentation, and for being willing to take our questions. As I said, we'll have in our final session of the day, we'll have a chance to take questions for all of the speakers for the day. And looking at some of the others that came in, I think they might fit really well in that session as we start to look forward to the present. And some of our audience were asking you to apply past to present. So look forward to hearing answers to those questions in our final session of the day. Our next session, entitled FDR's 1937 Court Packing Controversy and Other Court Curving Attempts, will begin in about 5 to 10 minutes at around 11 a.m. Mountain Time. If you want to attend in person, we'll head down to room 101C of the Clark Building. So it's the building we're in right now. For those joining online, the broadcast will resume when the next session begins. And again, that's going to be about 5 to 10 minutes. Thank you, everyone. Oh, yeah, yeah.
They're doing well. Through that round. I always like the sure. It's not like Four different schools. Yeah.
Well,
Actually, this is the kind of place.
Yeah, they've got to.
Dr. Jones got Yeah, this is on.
Or on the basis of our vision,
Finally. So, well,
that furnishes, that furnishes the most.
Will you just make sure that
yeah.
somebody teams me?
Hey,
and they're
Carrie?
ready to go? So that we can-
Is it 101? Oh, I bet it's one of the large
Does that make sense? Yes.
elevators over here,
We
or the
thought
large
that
section
first
rooms.
Bill Art
on
on
the
to
end.
Okay, so when you say when you're gonna start. Sorry, when Scott is ready to start the session, okay. Teams, send me a team so that we can, and then I'll send back and say, okay, we're live. Sweet, okay, thank you. I'm ready to go.
Constitution Day commemoration. And so I'll just start with a quick question. When was the US Constitution signed? Not ratified, signed. What day?
Well, was it signed in 76? Was that like 87?
1787. And does anyone know the date that it was signed?
September 17th.
September 17th. Okay, good. So I want to actually start just by reading from a website that a competing center for constitutional studies who also celebrates Constitution Day. So this is the National Center for Constitutional Studies. On September 17, 1787, the founding fathers signed the most influential document in American history, the U.S. Constitution. Every year, the National Constitution Center hosts the best Constitution Day celebration in the country. So I respectfully disagree. I would argue that UVU hosts at least one of the best Constitution Day events in the country. And as evidence of that, we have upped our game and now celebrate Constitution Week, which is why we have an event on September 16th as well as 17th. So I'm glad you're all here with us today. I will just end quickly with two housekeeping points just to keep us on track today. For students in the class, please stay tuned at the end of class for an announcement in Canvas. You'll be able to submit your notes there. And at the end of class, if anyone has any questions, we just ask you to put up your hands and we'll bring you a microphone. So just please wait until we bring you the microphone. With that, I hope you enjoy the programming today, and I will turn the time over to our moderator for today's session, Grace Mallon.
Thank you so much, Dr. Bibby, and thank you to the Centre for Constitutional Studies for having me and our speakers for this next panel, which is entitled FDR's 1937 Court Packing Controversy and Other Court Curbing Attempts. And I should say before we kick off that each session today will include time for questions from the audience. These will be important to our session today. We're looking forward to your questions. So whether you're here in person or watching live online, we encourage you to submit questions either in the chat function of the YouTube channel or by emailing constitution@uvu.edu. That's constitution@uvu.edu. So we're going to hear from two speakers in today's panel. They're each going to speak for about 25 minutes. And I think I'm just going to introduce both of them before we kick off, if that's okay with them. And one of them is going to be on the screen and one of them is in the room with you. So on the screen with me is Professor William G. Ross, who is the Albert P. Brewer Professor of Law and Ethics at the Cumberland School of Law of Stanford University. That's Sam, not Stan. A graduate of Stanford and Harvard Law School, he practiced law in Manhattan for 9 years before joining the Cumberland faculty in 1988. And he's published several books on a range of topics in legal scholarship, among them several on constitutional history. These include A Muted Fury, Populist Progressives and Labor Unions Confront the Courts, 1890 to 1937, The Chief Justiceship of Charles Evans Hughes, 1930 to 1941, and World War I and the American Constitution, which was published by Cambridge University Press in 2017. And our second speaker is Alex Badass, is an assistant professor of political science at the University of Houston. His research focuses on judicial politics and covers topics such as public attitudes towards the judiciary and judicial decision-making. And he's published a lot on this, as you can see from his faculty page, or as I saw from his faculty page. And he got his PhD at Indiana University. So with that, I think we'll ask Professor Ross to kick off.
Professor Ross, I think you're muted. Professor Ross.
I think I was muted, wasn't I? Yeah, pardon me. Okay, so I'll start over again. Thank you for the introduction, and I'm glad that you're indulging me here on Zoom. I'd rather be there in person, but glad to be here electronically. So in order to understand the court packing plan that President Roosevelt proposed in 1937, I think we need to go back at least 50 years to explore the context. With the industrialization of the United States during the 19th century, there was a growing sense that there were many abuses of the Industrial Revolution that needed to be ameliorated through legislation. And since the federal and state government prior to the late 19th century had largely been a government of laissez-faire, it had been largely inert except during wartime, except for a few activities like delivering the mail. The enactment of legislation that directly affected economic activity, particularly employees and workers, it was highly controversial, both politically and judicially. And the courts really didn't know what to do with this legislation. The states had a broad police power to regulate for the public health, safety, welfare, and morals of the people. Congress had enumerated powers, particularly the commerce power and the taxing power, that could arguably support economic regulatory legislation. But courts were uneven in their responses to the legislation when they exercised their power of judicial review. So on the whole, the courts, both state courts and the federal courts, including the U.S. Supreme Court, sustained the constitutionality of these raft of economic regulatory measures. But on a number of important occasions, the Supreme Court and other courts invalidated the legislation, saying that they exceeded the powers of the state or exceeded the powers of the Congress. Probably the most famous case or the most emblematic case was the Lochner decision in 1905, where the U.S. Supreme Court 5-4 struck down a New York statute that had regulated the number of hours that bakers could work. This was designed to protect the health of the bakers, but the U.S. Supreme Court said that it denied both the employers and the employees liberty of contract in violation of the Due Process Clause of the 14th Amendment because it was largely unnecessary. The court also held that a number of important federal statutes exceeded the taxing and commerce power. Among the most famous of those were the court's two decisions in 1918 and 1922, striking down federal child labor laws, saying that they exceeded the power of Congress to regulate commerce and also exceeded the taxing power. With the Great Depression in 1933, of course, there was an enormous increase in federal legislation to try to ameliorate the effects of the Great Depression and to institute reforms that would prevent the recurrence of economic chaos. This legislation, of course, collectively is known as the New Deal legislation of President Roosevelt. The Supreme Court's response to this legislation when the cases worked their way up to the court during 1935 and 1936 was for the most part very negative. The court struck down several high-profile New Deal statutes, struck down legislation that provided price supports for farmers, struck down a far-reaching regulation of the coal industry that tried to improve the production of workers and stabilize coal prices and production. It also struck down a railroad pension law that was kind of a prototype for Social Security. So it looked like the court was on kind of a collision course with the Roosevelt administration. Roosevelt bided his time. He was very careful at first not to openly criticize the United States Supreme Court. In the past, that had been political poison. Political candidates who had dared to suggest that the Supreme Court had exceeded its powers, or that the Supreme Court should somehow be curtailed, had generally found that they lost votes as a result of that. The nullification of regulatory legislation during the 50 years preceding 1937 had generated a large number of proposals for curtailing judicial review. There were suggestions, for example, that Congress ought to have the power to overturn Supreme Court decisions. There were proposals to require a supermajority. Many of these high-profile decisions were 5-4 decisions. So some people said that the Supreme Court ought to have be required to have a vote of 6-3 or 7-2 or 8-1 or even be unanimous before it could strike down legislation. There were proposals to curtail the jurisdiction of the U.S. Supreme Court over certain types of legislation pursuant to the exceptions clause of Article 3 of the Constitution. And there were also proposals for constitutional amendments. None of these proposals ever really went very far. Most of them never even made it to congressional committees. Probably the most notable exception was the income tax amendment in 1913. After the Supreme Court in 1895 had held that the Congress did not have the power to enact an income tax, an amendment was added to the Constitution in 1913 to permit an income tax. But of course, the amendment process is very difficult. It requires the concurrence of 2/3 of both houses of Congress and 3/4 of the state legislatures. So for the most part, it was not practicable to overturn Supreme Court decisions nullifying regulatory legislation by constitutional amendment. And probably the most famous example was the effort to overturn the court's child labor decisions. Majority of more than 2/3 of Congress approved an amendment prohibiting child labor. But that was sent on to the states. It got a majority, but it could never muster the 3/4 majority needed for enactment. The critics of the courts throughout this period were very frustrated. It didn't seem like they could curtail the power of the court. They couldn't enact constitutional amendments. So they just could only hope that the court would sustain the constitutionality of regulatory legislation. But President Roosevelt in 1936, after he was reelected in a landslide, was very worried that the Supreme Court would strike down 3 of the most important pieces of New Deal legislation. The old age pension provisions of the Social Security Act and the unemployment provisions of the Social Security Act and the National Labor Relations Act. The United States in the 1930s was roiled by industrial unrest. Now, there were many strikes. There was violence in a number of industries between management and labor. Roosevelt and the supporters of the New Deal wanted to have the government take a much broader role in trying to settle industrial disputes. So the National Labor Relations Act was hugely important. The fate of the National Labor Relations Act and the old age pension and unemployment provisions of the Social Security Act rested with the U.S. Supreme Court. And based on the court's invalidation of a swath of New Deal legislation during the previous 2 years, it looked like the court may very well strike down those statutes. So after Roosevelt was reelected, with electoral majority of 523 to 8, more than 60% of the vote in November 1936, it was clear that Roosevelt was almost going to have to do something, as it were, about the U.S. Supreme Court. Many people thought that he would propose a constitutional amendment that would address these issues. But again, Roosevelt remembered painfully how the child labor amendment had never gotten through the requisite number of state legislatures. And he did not consider that to be practicable. So finally, on February 5th, 1937, he stunned the nation with his proposal for so-called court packing. He proposed legislation to add 6 justices to the U.S. Supreme Court and approximately 50 judges in the lower federal judiciary, 1 for every judge who was over the age of 70, because Roosevelt pretended that the court packing plan was about helping out elderly justices. He said that the court was overburdened. The justices who were older than 70 might not be able to fully carry their workload, and they needed help. So 1 extra justice, 1 extra judge for everybody who was over the age of 70. Roosevelt, having been reelected by such a massive landslide, assumed that this would sail right through Congress. One of the interesting aspects of the court packing proposal is it did not affect the institutional powers of the U.S. Supreme Court. It merely changed the personnel who would exercise those powers. And many of the advocates of institutional reform among progressives and liberals were disappointed because they thought the Supreme Court itself had too much power, and this wouldn't actually have changed the court's power. Many other Americans were alarmed because they thought that this represented political interference with the court. President Roosevelt would be able to put his own people on the court, so to speak, and thereby able to manipulate the outcome of judicial decisions. And people ask, where will this end? So now we have a court of 15. If the next president doesn't like what the court's doing, is he going to appoint another 6 judges? I mean, are we going to end up with the court with 100 justices who are manipulated by the president for political reasons? And so Roosevelt found, to his astonishment, that many of his own supporters were highly critical of the plan. And some of his key constituencies, particularly organized labor and farmers and ethnic Americans, turned against the proposal almost immediately. The organized bar was highly critical of it. The American Bar Association launched a major campaign to defeat the measure. And Roosevelt found himself with surprisingly few supporters. And then things got even worse for him when Chief Justice Hughes notified the Senate Judiciary Committee that the court, in fact, was not behind in this workload, that none of the justices were overburdened, and that, in fact, the addition of justices would actually interfere with the court's ability to perform its work. It was more efficient to have a 9-member court than a 15-member court. And after that, Roosevelt admitted the political character of his proposal, that this was not so much about helping out elderly justices as it was to help to ensure that the court would sustain the New Deal legislation. And if he'd been more honest about the plan to start with, maybe he would have had more support. We'll never know. Well, then the court itself undermined Roosevelt's proposal by sustaining the constitutionality of a number of pieces of key legislation during the late part of March and early April. The court sustained the constitutionality of a Washington state minimum wage law for women on March 29th, 1937, even though the court only 9 months earlier had struck down an almost identical minimum wage law for women in the state of New York. Both of these were 5-4 decisions, but Justice Owen Roberts, changed his position between those 2 cases. So many people thought this might signal that the court's attitude, as it were, toward economic regulatory legislation had changed. And that was confirmed a couple of weeks later when the Supreme Court sustained the constitutionality of the National Labor Relations Act and the old age and unemployment compensation provisions of the Social Security Act. And so at this point, it looked like the Supreme Court had changed its course and that there really wasn't even supporters of regulatory legislation. Even the most ardent New Dealers did not need to have extra justices because the court was sustaining the economic regulations that they supported. So at that point, Roosevelt pushed on. He still tried to get the plan enacted. The support was further eroded in May when one of the most ardent opponents of regulatory legislation, Justice Vandevanter, announced his retirement. And Roosevelt then was able to replace him with a strong supporter of economic regulatory legislation, Senator Hugo Black of Alabama. So that seemed to further consolidate the pro-regulatory majority on the U.S. Supreme Court. Well, we'll never know, if the so-called switch in time that saved the 9, the transition toward a more pro-regulatory court during the spring of 1937 was motivated by fear of court packing or not. And that's one of the most hotly contested issues in American constitutional history. Many historians say, well, get real. The court was striking down this legislation before the court packing plan, and they suddenly started upholding it afterwards. So it looks like they were, in effect, frightened into sustaining the legislation. Here again, we're really only talking about one or two justices, particularly Justice Roberts, and to a less extent, Justice Hughes, the other Chief Justice Hughes. Most of the other justices voted the same way in cases both before and after the court packing plan. But some historians have found technical distinctions between the 1935 and 1936 cases striking down legislation and the 1937 cases sustaining the legislation. So it's not clear to what extent Roberts and Hughes were intimidated or influenced, as it were, by the court packing plan. But in any event, the Supreme Court since 1937 has virtually never struck down economic regulatory legislation, and it has since that time reviewed economic regulatory legislation with a very low level basis of scrutiny. Meanwhile, more justices gradually died or retired from the court. And by the time Roosevelt died in 1945, he had appointed or reappointed 8 of the 9 members of the U.S. Supreme Court. So in effect, Roosevelt lost the battle, but he won the war. And it was ultimately able to have a court that went on to sustain other measures during the so-called Second New Deal, particularly the 1938 legislation that established federal minimum wage and finally abolished child labor. So the court packing plan was in a sense a failure for Roosevelt, but looked at it another way, it was a kind of a triumph. So we continue to have 9 justices. We've had 9 justices, ever since 1869, actually all but 6 years since 1837. One of the reasons Roosevelt chose court packing, it was probably the easiest route. It didn't, as I said earlier, it didn't require a constitutional amendment. It didn't interfere with the institutional powers of the court. All it required was simple legislation, because the Constitution does not say how many members are to be on the U.S. Supreme Court. And the membership has varied over time, never exceeded 10, and then only for a few years. So it's been set at 9 for more than 150 years. And until last year, there have been virtually no more talk about court curbing, about court packing. And now, of course, there's legislation pending in both the Senate and the House to add 4 justices to the U.S. Supreme Court. So the court packing is back on the table after having been largely dormant for 80 years. After Roosevelt's court packing plan, it went down in flames. So we'll see what happens this time. President Biden has appointed a presidential commission to study issues involving court curbing and so-called court packing. And again, we'll see what happens. But in any event, the court was influenced by, or at least arguably influenced by the court packing plan in 1937. I think I have a few minutes left. I don't want to run over my time, but one aspect of the story that I left out, I'd like to go back to, is that the Supreme Court was during the period in which it was so highly criticized, by populists and progressives and organized labor for striking down economic regulatory legislation, had not yet begun to sustain civil liberties or personal liberties such as free speech, freedom of religion. It had not begun its modern role of protecting racial minorities until the 1920s. And then at a time in the 1920s when the court was under sustained attack for its decisions striking down economic regulatory legislation, it suddenly began to sustain or to strike down legislation that interfered with personal liberties, particularly free speech and freedom of religion. And it began to strike down laws that interfered with the rights of ethnic and racial minorities. And that bolstered support for the U.S. Supreme Court, and that was hugely important in the court packing fight of 1937. Because many ethnic minorities and racial minorities and religious minorities opposed Roosevelt's plan, even though most of those voters had supported Roosevelt's economic regulatory legislation, because they feared that if the court was politicized, if the court somehow lost some of its power, the court would no longer be able to protect personal liberties. So the opponents of the court packing plan reminded the American people again and again that the same power of judicial review that could be used to strike down a child labor law or a minimum wage law could also be used to strike down a law that interfered with free speech, which imposed special burdens on racial or religious or ethnic minorities. And many of the ethnic voters and who had strongly supported Roosevelt in the 1936 election, were among the most ardent opponents of the court packing plan, because they had come to regard the court as the guardian of personal liberties. And of course, the history of the Supreme Court since 1937 has largely been one of protection of personal liberties and protection of racial and ethnic and religious minorities. So at the very time in 1937, when the court kind of got out of the business of carefully scrutinizing economic regulatory legislation, it was kind of getting into the role of the guardian of civil and personal liberties, which it has continued to exercise today. So I think I'm more or less out of time, and so very much look forward to questions. Any questions? Ms. Mallon, this is the time to take questions.
I think we'll do questions at the end, if that's all right. I think I'm going to ask.
Well, in that case, I look very much forward to hearing Professor Beidos speak. Yeah, thank you.
All right. Thanks for having me. Thanks for putting my call. I'm really excited to be here. My name is Dr. Alex Beidos, and I'm from the University of Houston. Before having a job at the University of Houston, I was a PhD student at Indiana University with my doctorate. Today, I'll talk to you guys about judicial legitimacy and public attitudes towards court packing. Like Professor Ross, I'll talk a lot about the court packing plan in 1987, but then I also want to think about how we think about court packing today. Right? As Professor Ross highlighted, for the first time in about 80 years, court packing is becoming discussed in mainstream politics. So I want to see, how do people think about this today? I'll try to do two things at once here, three things that will also give the presentation. So let's see how well I do this. So this talk is largely based on an article I published in 2019 called Policy Disagreement and Judicial Legitimacy, Evidence from the 1937 Court Packing Plan. And this is published in the Journal of Legal Studies. So if you're interested in more details or just want to read it for your own enjoyment for whatever reason you may have, you can find it there. It's also on my personal website, which is just myname.com. So check it out if you want more details. So in my talk, what am I going to demonstrate to you guys? What am I going to show you is happening? So I'm going to demonstrate to you guys that evaluations of the Supreme Court's legitimacy are linked to an individual's ideological congruence with their court, right? And I'm going to demonstrate this using public opinion data from the 1937 Court Packing Plan. And as we kind of think about support for institutions, political scientists typically condense these two things into kind of two forms of support. One is what we'll call specific support, and this is typically short-term support for political institutions. Right? So basically, you're asking, do you support the policies that these institutions are producing? Right? So if we're thinking about the Supreme Court, maybe we're just going to think about, well, do we agree with the outcomes that the Supreme Court is making? Right? So in a recent case, the Supreme Court declined to file an injunction in a Texas law that basically bans abortion in Texas. Do you agree or disagree with that law? That would be a concept of specific support. On the other hand, we have diffuse support, or what's known as legitimacy, right? And this tends to be long-term support for political institutions, how they're structured, and their ability to exercise power for our political society, right? So this is no longer, do I agree or disagree with the decisions the Supreme Court is making, but rather, do I agree that the Supreme Court should have the authority to make decisions in the first place? And typically, when we look at the scholarly literature, these two concepts are seen as distinct, right? So just because you disagree with the outcomes the Supreme Court is producing doesn't mean you're going to start to attack or challenge the Supreme Court. And what I'm hoping to show you guys is these concepts aren't necessarily distinct, right? And as the public thinks about the court, they're kind of thinking of the court as they would maybe think of Congress or the executive. When you dislike them, you sort of want to take power away from them. And understanding how the public perceives the court's legitimacy is a very important topic, right? This is because the Supreme Court depends on legitimacy in a way that other political institutions necessarily do not, right? Other political institutions have regular elections, so they're kind of governed by the consent of the people, right? We elect our senator every 6 years. Therefore, our senators have a sense of democratic legitimacy to them. The Supreme Court justices are appointed by the president, and then they serve lifelong terms. So we, the people, have no direct say in what they're doing. Further compounding this difficulty of no kind of democratic legitimacy inherent in their appointments is the fact that they have no formal mechanism for enforcement, right? They neither have the power of the purse, so they can't fund their decisions, and they don't have the power of the sword, so they have no way of implementing their decisions. The only way they can have their decisions have power or influence is by convincing other actors to adopt them, right? And we see a lot of examples through history. Other actors oftentimes ignore Supreme Court decisions, right? So there's nothing inherent about a Supreme Court opinion that makes anyone do anything. Instead, we have to view the court as legitimate and follow their decisions even when we disagree with them. So we really want to understand how the public perceives the court's legitimacy and whether this is simply tied to whether you agree or disagree with the court's decisions, or whether we have a kind of democratic legitimacy granted to the Supreme Court out of the sense that we think it's good to have an independent judiciary or something. So I'll talk to you guys about some of the kind of existing theories for why we perceive the Supreme Court as legitimate. Probably the number one theory in the field right now is what we'll call positivity theory. And this is mostly authored by Jim Gibson and his colleagues, Greg Caldera, and in more recent times, Michael Nelson. So basically, their argument is that people see the court as a unique political institution, right? Or I should say a unique institution. They kind of view the court as outside of the realm of politics. And they argue that incongruence with the Supreme Court's decision is not going to cause you to have diminished views of that court's legitimacy. So even if the court is making a lot of decisions you disagree with, you're not going to tinker with the court's authority to make decisions because you understand that we should have a Supreme Court that decides these issues. They argue instead that when there's conflicts involving the court, these kind of prime what they call judiciousness, right? And we can kind of take a few examples of this. So this is a photo of the justices at one of the recent State of the Union addresses. And what we see is the justices are dressed in robes. All the senators are dressed in suits. So immediately from this picture, we see that the Supreme Court is different. They present themselves as different. This is the introduction. So this is the one time they'll stand and clap. But if you see, watch the rest of the speech, the justices just sit there and they don't move. Typically, the other members of Congress kind of hoot and holler, applause or boo if they disagree or agree with the president. But the Supreme Court justices just sit there. So by watching this, we get a sense, wow, the Supreme Court is a different type of institution. When we look at what the Supreme Court does, they also conduct their business much differently than the other institutions of government. If you were to turn on C-SPAN right now and maybe by happenstance catch a speech from Ted Cruz, who's my senator in Texas. Ted Cruz is a bombastic guy. He levels a lot of attacks against his political opponents. We may very well see that on C-SPAN right now. But if we tuned in, well, we can't tune into the Supreme Court, watch it live, but maybe if we wanted to watch the audio of the Supreme Court giving oral arguments, what we'll see is they're having a reasoned debate. When we kind of listen to the issues they're talking about issues in a very legalistic way, and they're not really talking about politics or attacking their opponents. Everything's considered in a legalistic tone. Right? There's not really politics to it. They're not asking, is this good for Republicans or is this good for Democrats? They're asking rather, how does one case apply to another? And this kind of gets to the third aspect of judiciousness is the language of the law itself. Again, when the Supreme Court makes its decisions, it justifies them in long, dense opinions, right? As some of you may have to read for your constitutional law classes. And this is very dense, but when you read those documents, you don't get the sense that this is inherently a political action, right? But if we look at what the Senate's doing, we see the senators oftentimes do validate their decision-making based on their ideologies, or say this is good for people who support or represent who I represent, right? So the court is different in that regard. And because anytime we start talking about the court, these images are prominent in that discourse, instead of thinking of the court as another political institution, we go, oh, you know what? The court is actually different than these other institutions. So these images that I just showed you reinforce a concept known as procedural fairness. And this just reminds individuals that the Supreme Court is different than other political institutions. And procedural fairness is just the idea that the court goes through a fair and neutral process that's not biased towards one group or another. So everyone gets a fair say at the Supreme Court. And even if we don't like the outcome that a decision produced, we say, hey, at least the losing party had a fair shot to have their case heard. So we're going to say, okay, we understand that the court is a legitimate institution. They gave everyone a fair stake. In the other theory, it doesn't have such a clever name yet as positivity biased. And I think the researchers are still kind of trying to work up something really interesting to make it a little more catchy, but I'll just call it updating legitimacy evaluations based on policy congruence, right? Mouthful. So this is just the idea that when the Supreme Court does make decisions you disagree with, you're going to get mad at the Supreme Court. You're going to want to sanction the Supreme Court, right? Because you have loyalty to your partisan preferences or the ideological preferences over any sense of institutional loyalty to the Supreme Court. Right, so individuals who face disagreement at the Supreme Court are going to want to sanction this. Maybe this is through court packing. Maybe this is through adding term limits for the Supreme Court or changing its jurisdiction. There's a lot of forms of this. So decreasing perceptions of the court's legitimacy, saying, you know what, I no longer believe the court should have the right to make these decisions, right, through some kind of institutional reform. And so there's been a wide debate over which of these theories is actually reflective of truth, right? And each side produces some evidence using survey experiments or just regular surveys to see how attitudes about policy congruence kind of correlate to these outcome measures. But really, the current debate is problematic in many ways. And a lot of it has to do with how we actually measure judicial legitimacy. And I understand for a lot of government 101 students, this is not the most interesting topic, but it's sort of what we have to go through to get to the bigger bulk here. And if you look at how we currently measure judicial legitimacy, so if I wanted to survey all of you on how you viewed the Supreme Court, I'd ask you typically these 4 questions that were invented by Jim Gibson. So one of them is very stark, right? It says, if the Supreme Court starts making decisions most people disagree with, it might just be better to do away with the Supreme Court altogether, right? So this is kind of the absolute no legitimacy for the court. It should have no power whatsoever. We just demolish it with a bulldozer, right? We get rid of the Supreme Court altogether. Then we also ask them if the right of the Supreme Court to decide certain types of controversial issues should be reduced, right? So maybe we think the Supreme Court is handling a lot of issues that are best left to the legislator. So maybe we reduce their jurisdiction. And finally, one is the court should have the right to say what the Constitution means, even when the majority of people disagree with the court's decisions, right? So again, it's just the idea that we're going to grant the court power, even if we know there's potential for us to disagree with them. Right. And there's problems with this debate because these questions are really complex, right? And if we kind of think of them, and I'm assuming most of you guys are political science majors or have some kind of level of interest in politics, when you immediately see these, they're probably very difficult for you to answer. They involve a lot of kind of detailed concepts and things that nobody in politics is really proposing today. There's a lot of people who are currently upset at the Supreme Court, but no one is out there on a platform soapbox saying, let's demolish the Supreme Court, let's get rid of it altogether. So it's kind of outside of the realm of possibility. And we see a lot of these questions involve broad abstractions rather than support for specific policies or specific reforms. And a sense of public opinion research that has been going back for the last 70 to 80 years kind of shows that people don't necessarily have the political sophistication to answer these broad abstractions in a way that actually maps onto preferences towards specific policies and proposals. And in other research, I demonstrate that this is true in the context of the Supreme Court as well. These largely represent a hypothetical context. Again, nobody's asking anybody to do away with the Supreme Court. The question wording in these questions matters a lot. So if we go back here, and look at these questions that say, even when a majority of people disagree, if you change one word and make it say, even when the majority of people like me disagree, you get totally different answers to that, because people may perceive the majority as having different political beliefs than themselves. But if you ask saying, hey, if people like me disagree, they go, oh, okay, people like me, right? So they're going to impute their political preferences onto that and say, yes, let's diminish the court's ability to have these decision-making abilities. Right. And all of this kind of leads to a stalemate in this debate of whether there's actually a difference between specific support and legitimacy. And again, if we want to understand the Supreme Court's role in society and kind of understand when it's going to have the ability and capacity to make decisions, this is a debate that we want to resolve. Right? So what I want to do is to say, hey, let's actually analyze periods in time where the court actually did face a credible threat against its institutional structure. So we want to look at historical periods where the court was particularly vulnerable and see how the public responded to those actions, right? So a lot of this will have been said by Professor Ross, at least the details, the summary events of the details, but I'm gonna go over it again because I know college students a lot of times have a very short attention span, and you might need the details highlighted for you again. So FDR proposed the Judicial Procedures Reform Bill of 1987, and this would basically allow him to appoint one new justice for every justice who was over the age of 70 and had already served 10 years. As Professor Ross said, he kind of pitched this as an idea to help the elderly on the Supreme Court do their jobs a little bit better. The end result would be FDR gets to appoint 6 additional justices, which would give him a supermajority on the court. Right? And we can really see what FDR's motivation for the court packing plan was. Here's just a graph that shows us the number of laws declared unconstitutional over time. And what we see is a strong increase in the laws declared unconstitutional during FDR's first term. So the shaded region here is FDR's first term. And if we look back in history before the shaded region, when the Supreme Court was declaring these laws unconstitutional, these are relatively unimportant laws, right? No one's really batting an eye when the Supreme Court declares them unconstitutional. When you get to this period here, the Supreme Court is declaring landmark laws unconstitutional that large majorities in Congress passed and wanted, right? We also have to consider the context. We're in the Great Depression, a very strong, a very difficult time for the country. So FDR is trying to help the country get out of the Great Depression, and the court's sort of preventing him from doing that by declaring these laws unconstitutional. And we have what's known as Black Monday, where basically the Supreme Court declares a lot of New Deal legislation unconstitutional, leaving FDR unable to implement the New Deal. Right, he's not allowed to fire executive officials as he wants. They're declaring things like the National Recovery Act, the Agricultural Readjustment Act, which sort of guaranteed prices for crops, because during the Depression, it actually cost more money to raise the crops than you could actually sell them for. So there's price controls put in. The Supreme Court's declaring those things unconstitutional here. And this is kind of the last line for FDR. He says, okay, I have to do something now. I have to do something to combat the Supreme Court. So he did this by introducing the court packing plan. At first, Roosevelt did claim that his plan was nothing novel or radical. He noted that the size of the Supreme Court has changed many times over history, but really that's not true. If we look at the other times in which the size of the Supreme Court changed, they're mostly due to the expanding size of the country, right? So before current times, the Supreme Court justices actually had to go ride the circuit courts, right? So they would not only be a Supreme Court judge, but they'd actually have to go serve on the circuit courts as well. So every time the country kind of grew, we would need a few more justices so they could fill those circuits, right? We do have some kind of political maneuvering. The early Federalists tried to limit the size of the Supreme Court. They tried to switch the number of justices to lower here, but basically they lost power in the next election, and the Jeffersonian Democratic Republicans came in and overturned that law. So that's one kind of example of a political context here where they're trying to limit the future power of the judiciary, quickly overturned. And so most of these are benign things about the expanding size of the country. Right. So Roosevelt's plan, we can kind of see it as something novel, right? He's trying to change the size of the Supreme Court, mostly for political reasons. Right? And he described this as an effort to empower the court, to make them be able to do their jobs better. And again, that's not really the case. And he does let that slip too. It's not as if he's only trying to pitch this as a neutral way to increase efficiency. He's also saying, hey, the court is invalidating a lot of New Deal legislation. We need this legislation to fight us out of the New Deal. These new justices will allow us to combat the Great Depression. So we understand that he's doing this for political reasons, even if at times he's saying, hey, we're going to do this to help old people. And if we look at the public opinion at the time of the FDR court packing plan, a majority of the public actually believed the plan would pass, right? So based on surveys conducted at the time, right? So this is the earliest period of survey research. And to get this data, I looked through a whole bunch of archives at the Roper Archives, which is an internet source that maintains public opinion polling from 1930 to forward, basically. So it's an incredible data set. So a majority of people said, okay, yeah, we actually think this plan will pass. Right, so that demonstrates there's some kind of credibility of it among the American people. And they also thought it would diminish the court's authority overall. Right? So there's this understanding that they think it's going to change the court's institutional power. Legal elites at the time also called it a crisis for the court and constitution. In testimonies, professors from Harvard Law remarked that this would create a negative precedent for the court, basically where anytime anyone disagrees with the court, we're just going to add more and more justices. Right? And that becomes potentially problematic because then the court could have a massive, deliberative body of 100 people. Right? And that's maybe not something that's going to be too efficient. And as Professor Ross kind of highlighted, Chief Justice Hughes also denied that it would increase the efficiency of the court. And this is kind of a relatively unprecedented move for the Chief Justice of the Supreme Court to submit some kind of comment to Congress as they're debating anything. So he kind of felt strong enough to break this norm where the judiciary typically does not interfere in legislative reform. All right, and I want to make clear that increasing or decreasing the number of justices on the Supreme Court is not inherently an attack on the court's legitimacy. There are many neutral reasons why we could think of where we want a larger court. Maybe that we want the court to hear more cases. If we want the court to hear more cases, there maybe needs to be more justices to handle that workload. Maybe there's a lot of cases in the federal courts and we want to increase the number of justices or judges on the lower courts. Those are totally neutral reasons why we'd want to increase the court size. But context matters, right? And if we read the entire context here of the court packing plan, it is really a demonstration that FDR is trying to have a structural institutional change to the Supreme Court so the court is no longer to make the decisions that he does not like, right? So he's seeking institutional reform to better allow him to get decisions that he likes, right? He's doing this for purely political reasons. And if we kind of go beyond FDR's own motivations, it seems pretty clear that the public and legal elites saw it this way too. Right. So again, because I want to kind of test whether specific support and legitimacy are independent concepts, what I'm going to argue is that if these things are not independent concepts, so if policy incongruence does lead to diminished perceptions of the court's legitimacy, we should have two expectations or two hypotheses that we want to test. And the first is that the greater support for New Deal policies, so what the court is invalidating, should lead to people to favor the court packing plan. And two, those support for New Deal policies should make people more likely to actually want Congress to pass the plan, right? So Congress to actually do something rather than just saying, yes, I support the plan. You're actually going to want Congress to take this action. Right. So for my data sources, I'm using 1937 Gallup polls conducted in February. And my primarily dependent variable, so the thing I want to predict here is, do people support the court packing plan? And at the time, 75% said yes, 75% said no, and 10% had no opinion. So I'm just going to dichotomize this. And anyone that says yes, I'm going to treat as supporting the court packing plan. And anyone who says no or no opinion, I'm going to treat them as, kind of ambivalent or no preference. And then the second dependent variable that I'm interested in is, do they want Congress to actually pass the plan? So here there's a lot of different outcomes, right? You can pass the plan. 37% of the public said they'd want Congress to pass the plan. 21% said modify it. There were a few counter proposals out there that would either, one, allow FDR to appoint a smaller number of new justices, or two, not allow FDR to appoint any new justices, just to kind of, that particular plan was just kind of sending a signal to the court without any teeth to it. And then 35% wanted the Congress to defeat the plan altogether, not consider it. Again, 10% had no opinion. So here I'm just going to take everyone who says pass it, treat them as supporting it. Everyone who said something else as a zero to not support it, because I don't want to make any assumptions about these people who are saying modify it. Right. And then my key independent variable, so the thing I'm going to use to predict these things, is support for the New Deal. And there's some kind of problems that we may think of about relying on pre-1950 survey data because we're not really treating the data properly. It's kind of in its infancy. There's the use of quota-controlled sampling instead of probability-based sampling. And this basically is where survey researchers are sent to a town and they're asked to interview as many people as they can, trying to stick to certain demographics of that specific town.
But the survey researchers didn't want to go into low-income neighborhoods. They didn't want to go into minority neighborhoods. So oftentimes they would not interview these people, right? So these people are somewhat underrepresented in our sample. If we look back to these code books, a lot of them are very difficult to read, difficult to use. A lot of them are written in hand and then scanned later. So me as a researcher, it's very hard for me to kind of get a sense of what these code books are trying to do. Luckily, someone came before me and fixed a lot of these issues. Bernisky developed a series of survey weights that kind of get around these biases and how the surveyors actually chose people to survey. And then two, they also did a nice job of making the coding books more readable. And we actually use a lot of these post-survey stratification methods today. So this is kind of the gold standard. They just didn't know that in 1937. So we're kind of lucky. And to measure New Deal support, this is kind of a hard thing to capture because the New Deal is such a broad set of potential policies. So what I'm going to do is I'm going to use an item response theory model. It basically is a model that takes binary outcomes. So whether someone says yes or no to someone, and then turns them into a continuous latent concept. And so I'm using support for the 3 New Deal questions that were asked about in the survey. So maybe if you guys are familiar with DW nominate scores for members of Congress as a measure of ideology, or Martin Quinn scores for the Supreme Court, this is a very similar process that they use. And this is kind of technical details. And we can kind of see the distribution of support in the mass public here, right? So we see a lot of people do support the New Deal very much. A lot of people are not supportive at all. Typically, these are people who are ambivalent. They say, oh, I have no preference on this issue, and not people who are necessarily outwardly hostile of these things. Right. So then to model this, I'm going to use 2 logistic regressions, including these weights. I'm going to have some control variables because I really want to be sure that the outcome, New Deal support, that policy incongruence is the thing causing my results and not some potential confounder. So maybe they just really like FDR. FDR is kind of making the pitch. So they're going to make their evaluations on court packing solely as a function of how they perceive FDR. Well, there's also a survey question that asks, would they vote for FDR today? So I'm going to use this as a measure of kind of their affect towards FDR. And then I'm going to control for other factors such as ideology, age group, female, class, their professional occupation. As Professor Ross said, farmers were particularly opposed to the court packing plan. And this kind of captures that without really interfering with that key independent variable of interest. And all we have here are just 2 graphs that show us the results, right? So we see as support for the New Deal increases, so does the predicted probability that somebody is going to support the court packing plan. Over here, we also see the same thing, right? As support for court packing or support for New Deal increases, support for Congress passing the plan also increases, right? So what is the takeaway? Right? The takeaway here is that there's a strong correlation between specific support for the New Deal and wanting to sanction or damage the Supreme Court's institutional structure and its institutional power, right? So the implication here is that incongruence is associated with these ideas about giving the court power or taking the court's power away. Right, so kind of as Professor Ross also mentioned, right, the court packing plan in and of its own did nothing to the court's formal structure, right? No power is formally taken away. It's informally taken away because it allows FDR to have a supermajority in the court, right? So to kind of also answer this in this context, well, do these people who support the New Deal support other sanctions on the court as well? As Professor Ross said, some people argued that the Supreme Court should not be able to exercise judicial review anymore. So I'm going to, again, just test this theory kind of using the same setup here. I'm using it survey questions from the time, and I'm going to ask people whether they'd support limiting the court's ability to influence judicial review or not, right? And it's kind of the same level of support. At the time, 34% of people said yes, the Supreme Court should not have the ability to exercise judicial review. The rest said no or no opinion. And then 55% of people said that the court should be more liberal in the court packing on the New Deal measures. So I'm taking this as a measure of policy incongruence. So I'm just using, again, a logistic regression. This is when you have just a dependent variable that only takes a 0 or 1 value. And these are the results that we see. Again, when people want the court to be more liberal and they understand that the court is opposing those liberal New Deal policies, they're much more likely to support limiting the court's ability to exercise judicial review. Right, so it's, again, the same implication now, but we're actually looking at a formal mechanism to diminish the court's power rather than this informal, well, let's just have somebody make a lot of appointments to get the decisions they want. Right, so a lot of people, say that the FDR court packing plan failed, and it failed because it was drastically unpopular. But that's actually not true, right? There's alternative reasons that the court packing plan may have failed. Right, one is the switch in time that saved 9, as Professor Ross highlighted. The court packing plan sort of put pressure on some of the Supreme Court justices. This pressure caused them to change how they vote. right? So as a result of wanting to protect the court's institutional structure, one of the justices said, okay, I'm going to back down. The institution is worth more than my individual preference here. So they started changing how they voted. Then we had the retirement that Professor Ross mentioned. This allowed FDR to get a majority on the court without needing the court packing plan. So as a result of these two things, there is no need for the court packing plan anymore. FDR already has what he wants. And these two events really were pressured by the court packing plan. There's also some things FDR could have done better, right? The death of the majority leader Robinson happened during this time. Robinson was a very strong advocate for the court packing plan. His replacement less so. There's also some poor legislative strategy on Roosevelt's part that maybe got the plan a little bit of bad press. He didn't really send good supporters in to give testimony, but the opposition gave a lot of testimony, and that was talked about in the media a lot. So I think the important takeaway is the court packing plan did not fail. And if you look in FDR's second term, the Supreme Court invalidated no legislation at all. Right? So that's a pretty big tell, right? We go from having all of these laws declared unconstitutional to absolutely nothing for the next 4 years. So FDR gets a big win. Right, and I'll kind of skip over some of the implications because who cares, right? And we'll move into a talk about court packing today because I think that's exciting, right? So court packing is receiving new interest in today's society, which again is kind of novel because we haven't really had these conversations in 80 years. And we see the renewed interest in court packing plan because of the polarization of the nomination and confirmation process in the last 4 to 6 years now. Justice Scalia died. President Obama was in the last year of his administration. He advanced a nominee. The Republicans controlled the Senate at the time and just said, well, too bad, we're going to wait until the election is over to fill the seat. And that's what happened. And then fast forward a few years, the same thing happens for President Trump, right? Ruth Bader Ginsburg dies in the final year of his term. The Republicans still control the Senate. And they say, well, we're going to confirm a nominee, right? So there's a switch here. And they understand that this is the strategy we need to take to get people we agree with on the court, right? The Republicans in the Senate are motivated by getting Republicans on the court. Democrats are sort of mad about this. So they said, as payback and to rebalance the court, we should introduce court packing. Right? And we see this after the death of Ruth Bader Ginsburg. We see the discussions of court packing in the New York Times. We see that the presidential candidates for the Democratic primary were asked about court packing. And we actually see that even though the majority of them say no, they're not necessarily going to consider court packing. We see a lot of the nominees were open to it. And this was something that received time in the debates. And the amount of things that receive time at the debates is kind of relatively small. So that they're asking about court packing is actually a pretty good signal that this has entered some kind of mainstream discussion right now. And then, as Professor Ross said, there's currently a commission evaluating Supreme Court reforms, and the discussion of court packing is happening in those commission hearings. So again, it shows that this is being taken somewhat seriously, and Democrats in both the House and Senate have introduced legislation to change the number of justices on the Supreme Court. We should all kind of have an inherent belief that this legislation won't pass. But again, the Democrats in Congress are sending signals to their constituency that this is something they value, right? And maybe trying to gain more support because they favor these specific policies. So I kind of want to ask in the second part of my talk is the court facing a similar crisis today? And we saw that a lot of people supported the court packing plan, and a lot of people who were specifically kind of outraged at the court supported the court packing plan. So what I did was I searched public opinion archives for questions on modern ideas of court packing. So where does the public stand today? So here's just another graph that shows how much people support or oppose the court packing plan over this 3-year period in time. So this is about 13 polls. It's been asked about 13 times in the last 3 years. We see that most people still oppose court packing, right? Maybe a slight increase going on in the most recent poll, but that could just be, one single poll. We need more data to have firmer conclusions. So overall, we'll say, support for court packing is low, but the responses are highly polarized. So if we did look at particular parties now, we see that a majority of Democrats actually would support court packing. So what this kind of leads us to is because the majority of Democrats support this, well, it could kind of create a context where Democratic politicians want to kind of broadcast their support for court packing and push court packing because they understand their core constituency wants that. So we may think of a context where even though overall the popularity of court packing is low, Democratic politicians still want to adopt court packing because they have to first win a primary election, right? So because they have to win the primary, they're going to do things that are very popular with that base. So they may run on a platform saying, hey, I support reforms to the Supreme Court. And so in previous research, a colleague and I find that the Supreme Court is able to mobilize voters, and people do make their vote choice based on whether they agree with how their senator votes on judicial nominations. And we also saw that people do tend to select candidates who are promising to vote, nominate conservative individuals, right? If they're Republicans. For Democrats, we didn't find too many support there, but it's in the context of the president was Trump. The Democrats probably understand that President Trump is not going to nominate anyone they'd like anyways, right? So, we kind of want to update the study and see how these people respond now that they're in power and can potentially make these decisions. So we basically do a conjoint experiment, and this just kind of broadcasts 2 random profiles to people, and we ask them to choose one. We say, hey, these are 2 candidates in a primary election. They're both Democrats. Choose which candidate you'd most prefer, and we vary a lot of information about the candidate, including what issue they give their #1 priority to. And so we include a lot of things that are typical of the Democratic Party: pro-choice policies, increased taxation, increased regulation, things like that. But we also include an item about expanding the size of the Supreme Court, right, to get at this idea of court packing. So this is what people would see as they're participating in our experiment, just so you guys can get a sense of it. They get 2 candidates and a lot of different information about them. And this is all just randomized, right? We're just giving them random information to see how they respond to certain things. And then we ask them to choose. Right? And we fielded this on a survey platform, and we had about 750 participants. They look at 5 profiles each. There's 2 profiles, 2 candidates per page. So our sample size was 7,500. And here are the results to that #1 issue. And the important thing here is the dotted line means this has no effect on how people vote, right? It's 0. It doesn't influence them one way or the other. The positive values here, such as pass Medicare for all, that indicates that when a person sees that, they're more likely to choose that candidate. So that indicates that's a very popular item for people. But when we look at expanding the size of the Supreme Court, that's a negative issue, right? People who are running on the idea that the court should be expanded are actually chosen 5% less often than the baseline, right? So it shows, based on just whatever the replacement level issue for Democrats is, court packing is actually unpopular relative to that. And spending on space exploration was the least popular, which I find funny because I'm from Houston, where we have a lot of NASA stuff. So 1 minute. Okay, so basically the results just show us that court packing in the contemporary context is less popular, 5% less likely to be selected. And we maybe want to think about why. Well, it's not feasible. It's probably not going to pass. The gains are theoretical compared to more realistic policies. When we pass Medicare for all, we understand what we're getting. When we add justices to the Supreme Court, that's abstract, and it takes a lot of people mental energy to map that onto actual policies. And the elite cues are not consistent, right? So Democrats in the elite level support and oppose the policy. So as Democrats are kind of listening to their leaders, they're getting conflicting messages. Right? And there has not yet been a sustained losses at the Supreme Court, like we saw during the period of FDR, where it's going to enrage one party in a lot. Right? We may see that now that the Supreme Court's a little bit more conservative, but that's something we'll have to kind of pay attention to going forward. So just, to wrap up, does the Supreme Court face a similar crisis today? Well, not particularly. It looks like court packing is unpopular. And even though a majority of Democrats support it, they're not choosing candidates on that basis. But on the other hand, right, court packing is at least being discussed. And as we saw during the period of FDR, it doesn't have to pass to be influential. The justices are paying attention to these threats. And if there does become a point in time where we see that the popularity of court packing increases, the justices may feel the need to pay attention to that and change their behavior, even if no court packing is eventually passed. So I'm happy to answer questions. I have my email up here. You can also follow along on Twitter. I do tweet about my academic life at Betas Tweets. So thanks for having me, and I appreciate you guys being such a great audience.
Well, thank you so much to both of our speakers. I am informed that some of you may need to head off, but we do have a couple of questions. So if you do need to leave a little bit early, then do head off, and then I'll read out a couple of questions for the speakers to have a go at for us.
We'll give everyone just a minute to clear out. It's the class intermission, so.
Okay.
I think we're set to go with questions.
Okay, terrific. Should we have the questions from online? Yeah. So the first question is in two parts, and I think it'll go to either or both of our speakers. And the first question goes to something that relates to my own period of research, with the midnight judges and such. What is the precedent for appointing justices in the final months of a president's time in office? And the second part of that question is, how does that affect public opinion about the legitimacy of the court as an independent institution? So who wants to go first?
Professor Ross, you want to go ahead? I'll give deference to you if you have nothing else. I'll go ahead.
Professor Ross, did you want to have a go?
Yes, I couldn't hear the second question, but I think I heard the first about the precedents for appointing justices, by lame duck president, and that was tried a number of times, during the 19th century, and generally the Senate did not respond well to that, and many of these nominations were tabled, and we, of course, most of you probably familiar with the situation with Obama appointing Judge Garland during his last year in office, even though he was 10 months from the end of his term. The Republican Senate didn't act on that. Maybe the most famous example was Lyndon Johnson in June 1968, 7 months before his term expiring, appointing or nominating Abe Fortas to be Chief Justice when Earl Warren announced his retirement, and the Senate Republicans blocked Fortas's nomination. So, for the most part, the history of lame duck presidents nominating Supreme Court justices is not particularly good, and the experience with President Obama's nomination of Garland suggests that the lame duck period may be getting longer and longer. So it may be that in the future it might be difficult for a president who is not up for re-election, or even a president who is up for re-election during his or her last term, to have problems getting a nomination through the Senate. My own opinion is that as long as the president is the president, he or she should be given deference by the Senate in choice of a nominee. And the president has the power to make the nomination, and I think the Senate should consider the nomination even if the president's time in office is drawing to a close. Thank you.
And so kind of I'll build off Professor Ross's comments and then answer the second one about legitimacy, which I think I'm better equipped to do. But if you think of kind of just the timing of judicial vacancies on their own, they're semi-random because justices get to choose when to retire. And I think a lot of the justices has kind of had the sense that, well, everyone else, the president, the Congress, is very busy during an election year. So they kind of have an idea not to retire during this point in time, right? So if we actually look at the number of vacancies that occur during the president's final year in office, they're relatively rare, at least at the level of the Supreme Court. There's been more of a precedent for not confirming nominees in the last year for the lower courts, but right, whether the Supreme Court represents a special circumstance or a special case, that's something we can debate amongst ourselves. In terms of the legitimacy question of whether confirming or not confirming individuals in the last year of the president's term has any effect on legitimacy, it's kind of a hard question, because when we look at how the public perceives these things, and if you were to ask people during the Obama administration, well, should Merrick Garland get a confirmation hearing and ultimately be confirmed? Democrats say, yes, of course, right? This is a principle. Obama is still the president. And if we fast forward, 4 years and President Trump is in office, and now he's appointing or they want to hold the seat vacant or confirm the nominee before he's out, right? Amy Coney Bennett. Well, now the Republicans say, yes, of course we should confirm her, right? We should have a hearing confirmed. So basically people are kind of viewing this through their partisan attachments, right? So much about what we know about American politics and how the public responds to things is people really kind of base their ideas and base their attitudes based on their partisanship. One, because, it's an easy heuristic to use in a complicated world of politics. And two, these are the messages we're receiving from our political elites that we trust, right? So in terms of the legitimacy, what it probably further does is just polarize attitudes towards the courts. When Amy Coney Bennett is confirmed, Democrats now dislike the court even more because they feel like that's an unprincipled approach, whereas the Republicans say, yeah, this is good. We get something we like the court more. So I think that's probably how it's going to influence legitimacy rather than the public having some kind of attachment just to the idea that it's not fair or that it's fair to confirm somebody in the last year of someone's term.
Great. And the second question, the final question, before everybody goes to lunch. Has there been any correlation with public opinion views on the court with government in general? So I think that means that, yes, are views of the court attached to views of the other branches? And also there's interest in the public opinion data and where that came from. Sorry, you can probably read all of it.
Yeah, so I'll go ahead and answer the question, the first one first. So there is a recent article that demonstrates that people evaluate the court based on who the president is right now. So even if the president hasn't had an opportunity to make judicial appointments yet, people maybe naively believe that they have. Maybe they believe that the justices from the Supreme Court right now were appointed by Joe Biden. So people who tend to like Joe Biden right now will have a higher perceptions of the court's legitimacy because they're just making some kind of, non-informed inference based on who the president is. And for the data sources, I think these are in relation to the court packing plan data. I can't see the questions in front of me, but I received those from the Gallup archives. So those were Gallup questions from 1937. You can find these in the Roper archives, which is a database that includes public opinion polling from 1930, basically the genesis of public opinion till present day. It's a great archival thing.
Terrific. Thank you so much to our speakers and to our audience. And I hope everybody has a nice lunch and a good rest of the day.
Thank you.
Thank you very much.
Thank you, Professor Ross.
Thank you.
intense looking.
Thank you for doing your job. Makes us doing our job a lot easier.
I'll turn the time over to Joseph.
Yes, hello. I'm introducing Professor Epps. So Daniel Epps is a Trainman Professor of Law at Washington University in St. Louis, where his research and teaching revolve around constitutional law and criminal law and procedure. Professor Epps is a nationally recognized expert on the Supreme Court who is regularly quoted in the media, and he has appeared on CNN, MSNBC, and NPR. He has particular expertise in Supreme Court reform, where his work is influencing major policy debates. After presidential candidate Mayor Pete Buttigieg endorsed his and Ganesh Zimmerman's proposal to restructure the Supreme Court, the plan received widespread attention from the popular press. His legal scholarship has appeared in the Harvard Law Review, the Yale Law Journal, the University of Pennsylvania Law Review, the Michigan Law Review, the NYU Law Review, and the Vanderbilt Law Review. And his writing for popular audiences has appeared in the New York Times, Washington Post, Fox, and the Atlantic. He currently co-hosts with William Bogg Divided Arguments, a podcast that analyzes the Supreme Court's decisions. He is a graduate of Harvard Law School and a former law clerk for Supreme Court Justice Anthony Kennedy.
So thanks so much for that introduction. Can everybody hear me? I was having a little bit of audio issues for a second. I am not muted on my end. Shoot. Can anyone hear me yet? You can?
We can hear you now.
Great. Okay. Let me start things off. And I've been asked to talk about this question. Does the Supreme Court need saving? And that's kind of a play on an article I wrote that I'm going to talk about, article with Ganesh Sitaraman. And in this talk, I'm going to try to summarize some of the arguments we made in that piece, but also draw on some of my other writing about Supreme Court reform over the last couple of years. It's a topic I've been writing about a bunch. I probably should stop writing about it so much and find something else to write about. But I keep telling myself this will be the last thing I say about the topic before moving on, and I keep getting sucked back in. So let me go ahead and jump in, and let me tell you what I'm going to try to do today in my limited amount of time. I'm going to try to define the problem.
Professor Epps, I'm sorry to interrupt real quick. We
Yep.
have lost audio on you. So we're just going to tell you to hold up for a second, and then we'll
Sure.
give you the green light in a second.
Okay. Testing.
Our second may turn into a minute. I'll just keep you posted.
No worries.
All right, go ahead and try speaking right now.
Can you hear me?
No, it's not coming. It's not coming through on the.
The YouTube channel is working. If he wants to just keep going, we are live, so it's at least being recorded that way.
Okay. All right, it's not working to pipe you into our seminar room here, but you are being heard on YouTube Live, so we'll have you keep speaking to our online audience, and we will try to figure out a way to get the live audience catching up as soon as possible.
Sounds good. Thanks so much. And I think dealing with technical Zoom difficulties is just par for the course these days. I think we've all had to do a bunch of that, and I'm looking forward to the day when Zoom is a little bit more of an afterthought and not the thing that is a necessary tool for our daily professional life. So what I'm hoping to do is I'm going to try to define what I see as the problem with the court a little bit. I'm going to talk about the proposals that Ganesh Siddharaman and I have developed in our piece published in the Yale Law Journal, How to Save the Supreme Court in 2019. And then I'm going to talk about some other reforms that are on the table. I'm going to talk a little bit about what I see as the limits of those kinds of reforms and their feasibility and so forth. I'm going to briefly talk about the Biden Commission to think up sort of possible reforms to the Supreme Court. And then I'm going to close by talking about some sort of more feasible, more small ball alternatives that might be politically viable, even if big structural reform is not viable right now. So let's go ahead and talk about what I see as the problem. I think identifying the problem here is kind of is something that I think is going to be controversial. I think a lot of people may have questions, have going to argue about, but I'm going to try to say, here's why I think there's a problem with the Supreme Court right now. And I'm going to try to do that in a way that doesn't just depend on you disliking the current court. I will acknowledge that a lot of the debate about Supreme Court reform is going to turn a lot on whose ox is being gored, but I'm going to try to explain why I think that there are generally good reasons to recognize that there are problems. One thing is that we have a court that's increasingly polarized on partisan lines, not just polarized ideologically between sort of liberals and conservatives, but a court in which judicial ideology has a closer to a one-to-one correspondence to partisan allegiance. And we see that as people start sort of seeing the court more in terms of red and blue justices, and we're seeing that manifest, arguably increasingly in some of the highest profile cases. My colleague Lee Epstein sort of said that with the Kavanaugh argued that with the Kavanaugh nomination, the court had finally become fully aligned in a partisan way, and has raised some concerns about what that means for the court. We've also seen escalating norm breaking in confirmation battles as we go back and forth between, maybe depending on where you want to start the history. A lot of people like to start the history at the Bork nomination, where the Senate voted down Robert Bork's nomination to be Supreme Court Justice. But we've seen a further escalation in recent years when Majority Leader Mitch McConnell refused to hold a vote on Merrick Garland. Then we saw, among other things, we saw Justice Barrett confirmed just 8 days before the election. And we're also seeing politicians are really talking about reforms that would have been seen as unthinkable 5 years ago, 10 years ago. We're talking about a number of politicians who are putting forward plans to expand the size of the Supreme Court, what we call court packing, very controversial ideas that were previously seen as a third rail. These proposals are not yet, likely to be enacted. I mean, they're sort of on the kind of further on the left flank of the Democratic side, but even seeing that be talked about, seeing be part of the debate during presidential elections is pretty new. It's happened before in American history, but it hasn't happened in a long time. We're likely to see the court issue some pretty divisive rulings in the next few years as the court has moved further to the right. A lot of people will like those rulings. A lot of people won't like those rulings, but there is reason to suspect that those rulings will generate a lot of rancor. And a number of folks are also pointing to concerns about the court kind of participating in or failing to stop problems that things that are happening that undermine democracy. That's one thing that I think has probably more partisan valence for sure, but something that a lot of people on the left are pointing to. And it may explain a little bit why they see there's more urgency behind plans like court packing. They see the court as refusing to stop gerrymandering, refusing to stop voter identification, doing things that kind of restrict political power over groups that Democrats favor, and things like that. And they're concerned about that as we see an increasing battle over kind of who holds the power over elections in a democracy. And there's an argument that we're about to face a legitimacy crisis, that this is undermining the court's legitimacy. What that means is its kind of ability to resolve disputes in a way that people can live with, even if they don't like the bottom line. Are we there yet? Not obviously. I don't think it's hard for me to say we are there yet. And so as one example of that, show you a couple public opinion polls. These are both from last year, but we see one where, the public on the left, we have a Gallup poll where people are looking at impressions of the Supreme Court. Court is still doing reasonably well, does better than some of the other institutions of government. And so we've seen sort of a little bit more recent polls that have maybe had a small tick down, but I think I'm not ready to say the crisis is here and that the public has totally ready to embrace a crisis. But I think that the conditions have been laid, and particularly the way politicians are acting, for that to be pretty imminent. The other poll is a survey that was conducted by my colleague Lee Epstein and some co-authors, looking at public support for different kinds of court reform. One thing that's really interesting is there's overwhelming support for term limits, and then much less support for some other reforms. Not a lot of support for traditional court packing, and very little support for eliminating judicial review. So that's a set of caveats about, maybe we don't have a full-fledged crisis yet. But let me just talk about why I think it's still something we should care about and be worried about. And specifically, here's something, here's why I think that you should be concerned about that, regardless of what you think about the current court. It doesn't require you saying, I think this majority is illegitimate. And saying that there's a sort of brewing legitimacy crisis, and that there has been one in the past, doesn't require you saying the court is doing anything wrong. There were legitimacy crises when the court was doing things that were good, fighting segregation during the Warren Court. But nonetheless, when we start to see politicians really pushing back on the court, we should be concerned, because it does undermine the vision of the court as sort of a non-partisan institution that can resolve disputes. I think however you feel about it, I think I would suggest looking at the kind of things that have happened and imagining flipping it. Okay, if these were Democrats and the thing people were doing what they're doing and they're Democrats, and imagine that Republicans and vice versa. I think that's a helpful exercise in trying to see whether you agree there's a problem with the current state of affairs. But let me try to see if I can define what I see as the problem and what's causing it. We have some structural failings of constitutional design and settled practices that are kind of coming to a head right now. And particularly, I see it as the combination of life tenure, a really powerful court that strikes down legislation when it wants to and has a lot of authority to do that, the rise of political parties, and increased polarization among political parties, both in politics and in law. We see increased polarization in law, the rise of polarized schools of interpretation, and then we have a small fixed court size. If you add all those things up, control of the court turns on very small number of appointments, and those appointments are extremely consequential. If you get a majority or supermajority on the court for one party, that supermajority could retain power for decades or more, and that can be extremely consequential. And so what I have tried to do in my work with Ganesh Sitaraman is think about, are there ways we can reform the structures underlying the court that would kind of discourage partisan battles for court control and try to get ahead of any legitimacy crisis that we see as brewing. And our strategy is, I think one way to describe it is kind of power sharing. It's let's diffuse things by imagining a system where both political parties, people who that hold the White House over time, are going to have a fair amount of role in shaping who's on the court, and there's less ability for gamesmanship in terms of getting that one additional nomination to seize control of the court. We have two proposals that I'm going to summarize quite quickly, but I'm happy to talk about more in a moment. The first one is called the Supreme Court lottery. And what we said is, let's just take all the Court of Appeals judges in the country and let's formally designate them as Supreme Court justices. And let's just have them sit and randomly drawn panels for short periods of time. So rather than having 9 sort of philosopher kings and queens who rule from on high for all time and decide all the cases, we'll have sort of a much bigger group, and they'll come up and vote on some cases and go back down. We also have some tweaks on that. We say, you probably need to pair it with either a supermajority voting requirement or some kind of partisan balance requirement to prevent extreme swings. The other proposal that's gotten probably a bit more attention is called the balanced bench. And under that proposal, we would actually kind of embrace, oddly, we would kind of embrace partisanship in one sense in order to create a court that we hope would be less partisan, or at least seen as less partisan. And under this regime, you'd have 15 seats in the court, and you'd have 5 of them that sort of by law or by rule or by norm would be affiliated with Democratic Party, 5 that would be affiliated with the Republican Party. And we can talk about the mechanics of how you might do that later on. And then those 10 would have to pick 5 more justices who would sit by designation they would come up from the lower courts and sit by designation on the court for a period of time. And they'd have to do so unanimously. And the idea would be their motivation would not be to just pick rank partisans because they all have to agree. Both of these proposals, they're somewhat adventurous. I'll talk in a second about constitutional arguments in their favor and against them. But the basic idea is, let's be creative. Let's try to figure out, are there things we can do, ways we can just design the court or imagine a different court that might be less subject to some of the escalating pressures that are leading to these crises that we're seeing. And that would not be alternatives to something that are just what we see as purely partisan moves, like a partisan court backing, where Democrats get a supermajority in the Senate and they say, let's just add, 6 justices, 4 justices, whatever, and now we can reclaim control. Republicans do the same thing when they're in office. Our idea is, can we find some way, the system that we could live with over time? Are there constitutional problems? There are constitutional objections. Our view is that it is that there are reasonable responses to these constitutional objections, and there's a lot of features of our proposals that look somewhat similar to things that we already do. But for people who take a sort of very rigid originalist view, they're not going to be. They're not big supporters of our proposals. And I just want to acknowledge that. Problems that some people say you can't have a court that sits in panels because the Constitution says there should be one Supreme Court. I don't find that particularly persuasive because we have lots of courts that are one court, but that hear cases in panels. There's arguments about the appointments clause. If you have, for example, in our balanced bench proposal, if you're bringing up justices from the lower courts, is that a constitutional problem? Our position is no. We already have systems like this where many federal judges sit by designation on other courts without being formally appointed, but that's an objection. There's also argument that supermajority voting rules for the court might sort of unconstitutionally limit the court's power to exercise judicial review. And there's also arguments about any kind of partisan balance requirement on the court, that this would be a limitation on the president's power to appoint, other kinds of constitutional objections. But we note that there are other federal agencies that have similar requirements and have for decades, and they've worked, you can argue, but they've worked reasonably well. And in general, we think we have reasonable responses to these arguments, but of course, happy to debate them. Our balanced bench proposal got picked up by Mayor Buttigieg, which was great for getting attention. And was it because the proposal was so brilliant that he just happened to be reading law review articles? Maybe. Did it help that went to college with my co-author, probably more. And so the advice I would give is, if you're going to do scholarship, find co-authors who are friends with future presidential candidates, because it helps a lot. So I can't take credit for that, but for whatever reason, he got behind our balanced bench proposal, made a big issue out of it during the Democratic presidential primary. We got a lot of attention from pundits. They said a lot of great things. They said the clearly unconstitutional, constitutionally dubious. Jamal Bowie of the New York Times said it wouldn't solve the problems. And then my favorite one was The Week said it was an unwieldy mess, a soggy, not ready for prime time idea that manages to be profoundly infeasible while also seeming like it was designed by the naive compromise mongers at Third Way. And these are just the nice things that people said. But I digress. Shouldn't have showed you that. That's our proposals. Happy to talk about them. I want to just briefly, in the remaining time, talk about alternatives that are on the table. The one I've already alluded to, court packing, right? This is a totally different approach. It's a much more partisan approach. We could just say, Democrats have power. Let's add, there's Republican majority. Let's add 4 seats, retake the majority. A lot of objections to this. One is it would lead to escalation. And what's to stop the other side from doing it next time? Term limits. I've written a bit about term limits as well. There's a lot of interest in term limits, in particular 18-year term limits, where each president would have 2 appointments that would be fixed, and they'd be staggered. So, one justice comes off the court every 2 years. I think the reasons to think that would be an improvement. You don't have nominations turning on random chance the way that they do under our current system. You don't have strategic retirement where justices basically get to pick their successor, but it also would arguably make the court even more of an issue in presidential elections, even more of an issue than it already is, because you'd always know 2 seats on the court would hinge on this election. Some people are in favor of supermajority voting rules, so requiring more votes on the court in order to strike down a federal statute. A plan that's related to term limits that Daniel Hemmel at Chicago has proposed is, don't impose any term limits on the court, but say each president gets 2 appointments per term and they get to sit for life. You get no more than 2, no fewer than 2. We're not going to look at who retires or dies. I think that's probably better than the current system, because you don't, gets rid of the problem of strategic retirement, but maybe doesn't resolve some of the problems that I'm concerned about. Jurisdiction stripping. This is another particularly controversial one. Congress could just say the court shall have no power to hear cases involving X or Y. Insert whatever your favorite area is where you don't want the court mucking things around. Also controversial. It's a different kind of approach. It just basically says, let's get the court out of the way. All these things have been debated. One other possibility, though, is the court is just going to kind of check itself. The court is going to moderate. That's what it has done a lot of times in American history. The court will sort of do things that people don't really expect and sort of hew towards the center, and then turn down the temperature a little bit politically. Any of those things are possible. The last thing is that's probably the most plausible, but all these other ideas are being debated. One thing, point I just want to make, though, is, in some arguments we've had with other scholars on the right, they sort of say the solution is just, let's be originalists. The problem is the court's doing too much, so we just need justices to be originalists, textualists, follow the Constitution, and then everything will work out. I think that's a great solution. Sorry. Keeps muting me. Okay, sorry. I don't think that's a great solution, because originalism is, maybe it's a great idea in practice. I think in theory, in practice, it's insufficiently constraining. It's seen as political, and it's seen as tied up with substantive outcomes on the right. There are liberal originalists who would never get appointed to judicial office by Republicans. So I don't think this is the strategy, the solution to ending the crisis that we see. Now, as a result of a lot of this conversation about Supreme Court reform, President Biden got asked about it during the run-up to the election, and he kind of hemmed and hawed. And the solution that he came up with was, well, I'll appoint a commission on court reform, and I'll give them a mandate, and they'll come back and tell me what to do. It was a good kind of dodge, because it managed to kind of not alienate supporters on the left who really are geared up about court packing, but also to not freak out centrist voters who really would think court packing is frightening and not something that they want to support. It looks like probably really Biden has no appetite for doing that. This is just kind of a way to punt it down a little bit. The commission is in the middle of its work. I testified at one of the meetings a month or two ago. I think that it is unlikely to expect this commission very unlikely this commission will endorse any kind of structural reform. It's a bipartisan commission. It includes a number of very smart legal academics and a number that I think it fairly described as conservatives, who I think would be unlikely to endorse any reform that would be seen as kind of in a partisan way favoring Democrats. So I expect them to issue a report that will kind of maybe talk through all the possibilities, but not actually come down in favor of any of them. And for that reason, among others, I think it's very unlikely we're going to see major structural reform of the court, certainly in this first half of this presidential term. I do think that there are some other things that could happen, and I've written a little bit about alternatives to big structural reform that might be feasible in the short term. Ganesh Siddharaman and I wrote a short piece about that, and I turned it into a little op-ed in the Post. And I think that there's a lot of things that could fit into this category, things that might be able to get some bipartisan consensus. One being, let's impose ethics rules on the justices. Every federal judge in the country is under ethics rules except for Supreme Court justices. Sorry, I keep pressing the mute button accidentally instead of change slide. That was not the problem earlier. It's just the problem right now. Increased transparency. The court is a very secretive institution. The court hasn't even been live streaming its arguments until COVID. And so I think that there's been a lot of interest in Congress and elsewhere of trying to encourage the court to be a little bit more transparent. This can be tied up with ethics as well, because the court is not particularly forthcoming about financial disclosures. I think that's something where we could get some support for reform. There's a lot of interest right now in what we call what's been called the shadow docket, the court issuing these emergency orders that have consequential effect. I've called it the lightning docket. I think that's a slightly better name, but that hasn't caught on yet. But you heard it here first. And then we also proposed maybe changing the rules for the role of the Solicitor General in Supreme Court litigation. The Solicitor General is the official who represents the United States in the Supreme Court, and it's a position that is a political position and in some ways carries forward the goals of the administration. But we think that there might be ways you could sort of impose more rules on the Solicitor General that would make a little bit less of kind of a partisan yo-yo from administration to administration. But these are all much less modest reforms than the other ones we've been talking about. So, questions? Okay, I think I can hear something now.
Okay, got it. All right, can you hear me now, Professor Epps?
I sure can.
Okay, thank you very much for your presentation. Very fascinating, and we've been already getting some questions coming in on our YouTube channel, and I'm sure we'll also get some questions here from our live audience. So this is just a reminder to those of you watching remotely on YouTube that you can use the chat function on our YouTube channel to submit your questions or email them to constitution@uvu.org. So I'll go ahead and start with the first question that we received here online. This one is from Samuel Hill. He asks, Justice Breyer recently said that the court tends to right itself, that justices acclimatize to the behaviors and culture of the court after a few years. So his question is, why can't we follow Justice Breyer here and let the court moderate itself out of this crisis?
Yeah, so it's a really interesting question, and I think it does suggest one plausible path that will happen is that, and it historically has happened, and that the court there have been sort of people sounding the alarm about, the partisan balance of the court, and what ends up happening is the court does things that are unpredictable. Some members of the court maybe hew a little bit more towards the center. I think it might happen. I think it's plausible. I think that at the same time, a lot of actors in the system think it won't happen. For one example, if that were always going to happen, I'm not sure we would see, politicians fighting to, almost to the death over control over the court, because we recognize that partisan control of the court actually does matter, and it matters for a lot of outcomes. It may be that the court will hew in sort of more moderate directions on particularly visible issues. There may be less visible issues where that isn't the case. And it may also be, one reason to think that this might be different is, as I briefly mentioned, there are arguments that our legal culture is now more polarized than it was a generation ago, that we're seeing an increased divergence in the way liberal and conservative justices kind of even approach legal questions, the sources they look at, the scholars they cite, and there may be over time less room to find that kind of middle ground because they see issues so fundamentally differently. But I think that's possible. But I also don't think that we should just because a Supreme Court justice says everything is great is necessarily a reason for people in the public to just say, well, if Justice Breyer thinks it's great, it's great.
Okay, good. Thank you. Also from here, our live audience, who has a question that they'd like to ask for Professor Epps? Okay, yeah, go ahead.
So thinking about the pragmatics of this, what are some steps that you can take to put the ideal changes into place? And is it plausible that things will change soon in a way that is ideal?
The big picture answer to that question is no. I'd say in general, it's never plausible that things will change in a way that's ideal in any context, sadly, at least from my perspective. But here, I think it's not super plausible. And I say that, despite having proposed reforms that I would love to be enacted. One reason for that is there's a little bit of a paradox, in the sense that the reforms I think that are most likely to be seen as palatable, kind of the forms that are less partisan, more kind of good government reforms, are the ones that are least likely to be advanced because there's less in it for the political actors who are trying to push those reforms. At the same time, the reforms that political actors would gain the most from, sort of the most partisan reforms like court packing, are also going to be the most politically divisive and also the least likely to be enacted. That doesn't mean there's nothing to do, but I think what there is to do, and I guess that's really sort of what we were doing in our piece and our other work on this, is let's air these arguments. Let's have this conversation more out loud. Let's start thinking about possibilities. Let's just thinking about what's actually on the table, actually possible, and create a little bit more space for us to have this conversation and to think about what's, the options on the table in a way that, because that's sort of a necessary first step, and I think that, and certainly not because of us, but I think that, a lot of people did that. And that's what got us to even where we are, which is we have, mainstream, elected officials, members in Congress who are putting forward proposals to impose term limits on the court, to impose, to add extra justices. Those ideas would have been seen as pretty crazy, particularly the sort of court packing idea would have seen as really crazy just a few years ago. Maybe a lot of people still think it's crazy, but it's gotten a little bit less crazy. And so part of that is just you kind of move what they call the Overton window of what's seen as possible and reasonable.
Okay, great. Thank you very much. We'll turn back to the online questions for the next one. This participant asks, is there a consensus within the legal community that the media has exacerbated concern over the legitimacy of the court, or have their recent decisions contributed to this more? So I guess the question is, how much is the crisis that we sense a product of kind of the media's influence in hyping this, and how much of it is real?
So that's really interesting. I'd say in general, there's not as much when it comes to the Supreme Court. There's not as much consensus in the legal community, just period. And in general, I do think that a lot of people in the legal community do get frustrated with the media and how they kind of just sort of say the Republican justice did this, the Democratic justice to do that, and often the court does things that don't straightforwardly track party of appointment and their legal arguments, and there's legal actually illegal considerations at issue that are not just about who's going to win, who's going to lose, who's this going to hurt, who's this going to help. And I do think that just with respect to political scientists in the room, just looking at it without regard to the kind of technical legal considerations and just looking at the sort of party affiliation maybe doesn't capture that. That said, I do think that there is maybe increasing sense among some members of the legal community, and that's going to inevitably be the people who don't like what the court is doing. A sense among that side of the legal community that maybe now there really is a bigger problem, that we really should start thinking of justices as more tied up with their partisan affiliation than we should have even 10 years ago, that something is sort of moving. The court is becoming more partisan. Not everybody agrees with that, for sure, but I think that there is a vocal contingent of people who think that.
Okay, thank you. Let's turn back to our live audience now for the next question. Yeah, go ahead.
So this is kind of a two-part question. I asked it online as well, but why do you think there's more support for the balanced bench as opposed to the lottery system? And then he also mentioned that there were some issues that those could be abused. What are the ways those systems could be abused if they were to be implemented?
The second one was, what were the ways in which the systems could be? So I didn't quite catch it. Couldn't quite hear.
They could be abused.
Our reforms.
Yes.
Yeah. So in terms of the first question, I don't know. I think in terms of, it may just be that for whatever reason, Mayor Pete, got interested in that one, and that gave it more attention. I can say that the idea behind the balanced bench proposal was kind of inspiration from a dispute resolution model that we use in other areas of law and life. And there's a very common way that we arbitrate disputes. Let's say commercial disputes between countries, is you use a system of arbitration where each side gets to pick one of the decision makers. Let's say it's a three decision maker panel, and then those two have to agree on a third kind of neutral. And it's a system that, at least a lot of private parties, state actors find, reasonably satisfactory for resolving disputes. And so it may kind of capture some kind of intuition about kind of a fair mechanism for resolving these seemingly intractable disputes. In terms of abuse, I think it's very, very hard to design any Supreme Court reform that isn't capable of kind of breaking down if people don't play along. And so the current system turns out you can just have whoever controls the Senate can just say, you don't get any nominations. You, President, yeah, sure, there's a vacancy. There's 5 vacancies. You don't get to nominate anyone. The Republican senators were saying that was going to be their strategy if Hillary Clinton had been elected and they had held the Senate, that they just wouldn't have allowed her to fill any seats on the court. But you can imagine similar breakdowns happening with the term limit system. How do you deal with that? What if the Senate refuses to let what president nominate anyone? Our system, similarly, I think there's various places where it probably depends on some willingness to go along with the system, to fight for another day, and recognizing, yes, we're giving the other side this win, but then this is going to benefit us in the long term. And the fact that we don't seem to have that, maybe we're losing that a little bit in the current system, is part of the motivation for us to do this work. That the thing that we really worry about is things are breaking down, and there's less of a sense of, can we just all play by the rules that we followed along because it benefits everyone rather than let's just go for the ultimate win now. And I think that that kind of norm breaking escalation behavior is troublesome, and it suggests it portends, I think bad things, and we'd like to get out ahead of that.
Okay, thank you. So in the last few minutes, we want to bring in our other distinguished scholars here on this question. And Professor Epps's argument is about how to save the Supreme Court. But we want to ask Professors Batis, Brogdon, and Professor Ross, who's joining us online, to consider this question of, does the Supreme Court need saving? So maybe Professor Brogdon, will turn to you first, and then we can go from there.
Well, thank you, Merlin. And I don't know if, Daniel, can you hear me? I
sure can.
Okay, great. Well, thank you too for taking time to pipe in and join the conversation we're having today.
My pleasure.
It's provocative. I will say, I'm certainly in the camp of folks who would say that both the lottery and the balance bench are going to require constitutional amendments, not statutory reform. And you know, I have a laundry list of questions I would ask you with this, but I do want to add a consideration here, which is the core concern I think that Professor Epps raises is that the bench has become more polarized, that the partisan division, that the legal controversies on the court and the division over them tracks very closely or lays over very closely our partisan division. But I think that also has something of a simple explanation. American politics for the last generation was undergoing some pretty significant realignments. The South was moving Republican. You had all sorts of movement in the party system. There simply wasn't a coalition until, you know, we're about 20 years in to having a really stable party coalition or set of party coalition. So I think some of the enjoyment when we look back on the olden days and we go, oh, look back when there were some Democratic justices and they were kind of moderate, and there were some Republican justices and they were kind of moderate, and nobody was totally happy with their faction on the court or got what they wanted. You know, we had Justice O'Connor and Kennedy hanging around there, and occasionally some Democratic analogs to those sorts of, depending on how you define it, swing votes or traitors. You know, we kind of look back on that as the heyday, but the truth is they resulted from a party system that I don't think was well keyed to produce clear partisan distinction, because the populace itself was undergoing a lot of realignment up through the 90s. And now we've had good 2 decades now, several presidencies, where we've got pretty well-defined partisan boundaries. And I think that has simply manifested on the court. It's something that we maybe ignore a little bit. That also means that never lasts. That is never a permanent state of affairs. It's not even really a very long-standing state of affairs in American politics. About 3 decades is all you're good for, with clear party divisions in American politics, and then something blows it up. Sometimes it's really volatile and bad. Sometimes it's just the issues change, issue saliency changes. But I don't know what that thing will be, but I don't think it's all that terribly long in coming. Something will upset partisan division. Something will move people again to transgress party boundaries, to migrate in their partisanship. And I suspect that we'll see some of that messiness then translate onto the court, not to mention that the justices seem so clearly divided now. If you change the salient issues, suddenly Kavanaugh may not seem like a conservative anymore if the issues change. You know, I think, so I'm definitely in the let's not get too carried away here camp. I also do think that there is a phenomenon where most of the hand wringing is an intellectual elite and a political elite that is dominated by progressives. And I think that raises the temperature a little bit because most of the commentariat tends to be more alarmed by the change than they would be if the shoe was on the other foot. Though that's not a claim aimed against Professor Epps, who I have the highest respect for as a scholar who puts scholarly integrity above that sort of consideration. But I do think a lot of the temperature, a lot of the sort of sleep people are losing does have, in some ways, something to do with the fact that the pendulum's swinging to the right, and that's very alarming to the elite intelligentsia, which, you know, we've been accustomed to winning pretty much consistently, and that's. So I've got a lot more, but I'm gonna hush.
Okay.
And let's, talk, but that's my own, I felt like that was the one thing
Yeah.
I would throw in here that I think makes me feel a little.
That's great. Should I respond?
I think for the sake of time, we're going to go ahead and let the other two professors
cool.
Say their piece, and then we'd like you to respond to whichever or.
Okay, I've got to start taking notes so I can keep two things in my head at a time.
Okay. All right, Professor Batis.
I'm going to kind of, as any empirically minded scholar, try to sidestep the normative debate of whether the Supreme Court needs saving and speak more generally to the idea, are any of these feasible? And I think I'm actually going to build off of what I found that helpful. I think as we think about reforms, I've showed some polls that show some reforms did have a wide base of support. So if we look at support for term limits for the Supreme Court justices, sometimes those poll as high as 75 to 85% of the people support those reforms. The problem is, in our current moment, no one is advocating for those reforms. The second somebody in our Congress or an executive starts advocating for those reforms, they're going to polarize, right? Right now, one party benefits from the status quo in the Supreme Court. That's the Republican Party. There's 6 Republican appointed justices on the Supreme Court. There's one party who's upset by this, the Democrats, right? They understand that they're the minority on the Supreme Court. So if they want to make a change, even if it's something that's popular as term limits, the moment they introduce that as an idea, the elite masses are going to polarize, and that's going to cause polarization among the mass public. This is an idea known as conflict extension. So kind of where Matthew thought that new issues come up and that reorients our political realm. This is called realignment. There's a new theory developed by Tom Carson and Jeff Lehman that says increasingly, as new issues enter politics, more and more what's happening is they're just being absorbed into our current divides, right? Because the Democrats and Republicans are always in a contest against each other. Once a new issue comes up, the Democrats take a stance on it. Maybe this is term limits for the Supreme Court. The default response of Republicans is not to say, hey, that's a principled idea, I'm going to join up with you. It's to counteract that and say, no, we benefit from the status quo, so we're not going to support this. Now, Ted Cruz is my own senator, so I'm allowed to pick on him a little bit. So in the fallout of the Affordable Care Act case, Ted Cruz actually called for term limits for Supreme Court justices. If by some kind of chance the Biden Commission concludes that term limits for Supreme Court justices would be a remarkable idea, Ted Cruz is going to release a press release that moment saying this is a terrible, no good idea that's going to upset the legitimacy of the Supreme Court. And public opinion is going to divide based on his remarks. So I think due to the polarized times we live in and kind of the idea of conflict extension, I think any reform is very difficult. I don't think that means all hope is lost because as Professor Epps kind of noted, there's a tendency for the justices to moderate themselves. The justices have power. They want to keep that power. So they need to maintain their legitimacy. So if the 6 conservative justices on the court just want to go all the way and just start issuing conservative decision after conservative decision, that's probably going to raise more of concern among the Democrat elites and the Democrats in the mass public, where there could actually be some movement for reform. So the conservatives on the court are going to kind of exercise their power in a more principled way. So I think their hope and support for legitimacy is going to somewhat moderate them. And I think having these talks is good because it actually shows that some of these reforms are being considered. There are people who are upset at the current Supreme Court. They're considered an alternative. And the more we have events like this, the more they filter up to the Supreme Court, and the more the justices are aware of public sentiment and that their institutional structure is maybe not as stable as they think, and that will further cause them to moderate. While that doesn't necessarily lead to any institutional reform, it at least leads to the justices moderating their behavior because they know there's a movement in the mass public that is wanting them to do so.
Okay, thank you. And then we'll turn to Professor Ross. Just a minute. Do you have some comments you'd like to add?
Yes, thank you. There have been countless proposals to curtail judicial review or reform the court during the past century. And as Professor Epps has explained, many of these have been dusted off in the last few years, along with some very interesting new proposals that Professor Epps outlined. None of these many proposals in the past have ever obtained any serious traction. And I think probably as was pointed out earlier, the most popular one today would be term limits, but that's probably also the most difficult to achieve because it would require a constitutional amendment. So, I think it's unlikely that any of these proposals are probably going to be enacted. However, I like to emphasize that I think it is very useful to talk about them. I'm glad that Professor Epps and other scholars have placed these on the table because in the past, the various proposals to curtail judicial review or otherwise reform the court have reminded the justices that ultimately they are accountable to the Constitution and ultimately to the people. And at least indirectly, I think it has made them more responsive to the people and the needs of society. There's considerable evidence in the history of the court that these periodic reform movements have at least at some level influenced the justices in a positive way that probably have brought them more into line with mainstream political and constitutional thinking. So to that extent, I'm very pleased to see that we're talking about this today, and regardless of where these proposals actually go, I think they do serve a very useful purpose.
Okay, thank you. All right, we'll turn the time. Professor Epps, you've got a couple minutes to respond to your esteemed colleagues here, and you can pick on the particular points that you want to address.
So those are some really, really great comments. And I'm going to try to just do kind of a lightning round of responses to the extent possible. So Professor Brogdon, couple points. Yes, I think those are great observations about the rise of polarization in the parties. One caveat I'd add to that, though, is that increased polarization in the parties doesn't necessarily mean increased polarization in the court, because the court is mediated through legal culture. And what we see is even today, with a highly polarized system, we don't have Republican presidents, Democratic presidents, just let's find the kind of party hack we can put on. They said, let's find someone who has distinguished legal education. And to some extent, the more there is kind of consensus in legal culture about what counts as a right answer, the less we should see there being kind of partisan divisions on the court. But there has been a concerted effort through institutions like the Federal Society to create, I think, more of a divided legal culture that tracks partisanship for better or for worse. So Professor Badass, I think also I totally agree that how people feel about these reforms is going to change depending on what the political actors are going to tell them to do. One thing that's interesting about the survey I put up from my colleague, I think that 60% was for 6-year term limits, which is if you think about it, is actually crazy because it would mean the court would turn over 100% in a 2-term presidential administration. So, I mean, it does seem like people really do think that's a good idea, and of some kind, so having a longer term would presumably, in other polls gets even more support. So that does seem to be one where there's a lot of room to get public support. But I also agree that some of this language, some of these debates is going to cause the court to pull back. I have some reservations about how that happens, because I think what tends to happen is the court does some very public symbolic things, often on kind of culture wars issues, that get kind of the moderates, or make the other side happy. But then the things that I think often maybe matter more, the kind of division of power in society, the sort of big business cases, the relationship between labor and capital, they continue pursuing their agenda because for whatever reason that the sort of elites maybe care more about the kind of big picture cultural things than those disputes that I think maybe matter more. And Professor Ross, I think again, some similar point that I think there is value to this debate. I guess I might say that I think that you're right that probably most people conclude that term limits would require a constitutional amendment. Even there, though, I do think that there are some reasonable arguments that as long as justices retain their title for life, their salary for life, it's not obvious why you couldn't have one of these reforms like the Carrington and Crampton Reform Act that just says, well, for any given sitting, you go with the 9 most recently appointed justices. Is it the way you've been doing things? No. But, is it clearly contradicted by the text of the Constitution? I don't think so. And I think just because we've done things a certain way, we shouldn't necessarily assume they have to be done that way forever.
Okay, great. Thank you very much. Well, we've been going for about an hour, so I think we'll go ahead and wrap up. But I invite everyone to join us tomorrow morning. Start your Constitution Day off with us at the NORDA Concert Hall here at Utah Valley University, and we will continue our conversation about court packing and other structural challenges in U.S. Supreme Court history. I'd like to finish by just thanking again Professor Epps and his interlocutors for their excellent conversation and modeling civil discourse for us, and would like to finish by giving them a round of applause. Thank you.
Thanks. It was great.